Morning. Morning.
May your lordship,
Yes.
with consent from the other party, may I beg to mention item number 16 on behalf of Mr.
16.
Yes, your lordship, on behalf of Mr. O. Padar for the respondent.
You are for the
I'm for the respondent.
as prayed for by Mr. So-and-so, learned counsel for the respondent,
matter-
with consent from the petitioner, list this matter after 2 weeks on a date to be fixed by the registry.
Your lordship, the interim may be continued.
Interim, if any, shall continue to the next date. Yes.
Also, your lordship, item number 19.
19.
Yes, your lordship, on behalf of
Affidavit is to be filed. You wait for a turn.
your lordship, inadvertently, extra copy could not be furnished to the government advocate.
It's an order matter. Wait for your turn.
Lordship,
Don't make mention for orders. Yes.
My lordship, I beg to mention item number 5, lordship. Item number 5, lordship. Matter may be listed after 3 weeks, lordship.
Yes. What do you want?
Adjournment, lordship. Matter may be listed after 3 weeks, lordship.
Why?
Lordship, leading counsel is out of station and absent letter is also there.
Have you taken consent from the other?
Lordship, consent.
You are for the petitioner?
Lordship.
As prayed for by Mr. So-and-so, learned counsel for the petitioner, with consent from the other side, list this matter after 3 weeks on a date to be fixed by the registry.
Overlay.
Yama, if you don't know the name, you ask.
Lordship, I beg to mention item number 3.
3, yes. Constitution of Kabang is challenged here.
Yes,
Yes.
I'm appearing for respondent number 3 and 4 on behalf of El Parame, Standing Council Agriculture Department.
Have you taken consent from the
Yes.
petitioner?
Yes,
You've taken consent.
yes, I have taken consent.
As prayed for by Mr. So-and-so, learned counsel for respondent number
3 and 4.
3 and 4, with consent from the petitioner, list this matter after
After 2 weeks.
2 weeks on a date to be fixed by the registry.
And Lordship, item number 20.
20 is the order matter. Wait. Next.
No, my lord. My lord, I'm back to mention item number 27. It's a criminal appeal. No. Hearing. Item number 27.
Yes.
The matter may be fixed after 3 weeks. Lord.
You are for the
Appellant. Yes.
PP is there. Have you taken consent?
27.
As prayed for by Mr.
See nothing.
So-and-so, learned counsel for the petitioner, with consent from the other side, list this matter after 3 weeks on a date to be fixed by the registry.
Hello, Lord.
Next.
I would like to mention item number 28 here
28.
for adjournment.
28. Wait. You are for?
Tigame,
You are for respondent or petitioner?
appellant, Your Honor.
You are for the appellant. Have you informed the other side?
Yes, Your Honor.
You have informed. As prayed for by Mr. So-and-so, learned counsel for the petitioner, with consent from the other side, list this matter after 3 weeks on a date to be fixed by the registry. Yes.
I may be soon. And I beg to mention item number 10. Item
10.
number 10, Your Honor,
Yes.
on behalf of the petitioners. May be kindly fixed on 6th of May, Your Honor.
You want it on 6th May?
Yes, Your Honor.
As prayed for by MS So-and-so, with consent from the other side, list this matter on 6/5/2024.
Deeply obliged.
Madam,
Also, Your Honor, I
may I
beg to mention item number 20. Item number 26.
It's an order matter.
This is in
26.
orders. Yes, Your Honor.
No, it's a hearing. Yes.
In this case, Your Honor, the counsel for the respondent, Mr. T. Time, he is out of station.
Have you informed the petitioner?
Petitioner has been informed, Your Honor.
You have
Yes.
consent?
Yes, Your Honor.
As prayed for by MS So-and-so, with consent from the petitioner, list this matter
On 29th of
on
April.
so-and-so date. Next.
Madam, may I
DPO.
mention item number 6 and 7, madam?
Yes.
Here I am for the respondent number 1 and 2, madam. Madam, so far, madam, the respondent number 1 and 2 is concerned.
There is some, I think, records which was required to be produced in this matter.
Madam,
You
in fact,
wait for your turn, because I think there is some order. We'll accommodate.
Right.
You just wait. Call for the list.
My please, Lordship. My lord, this is,
Yes,
my lord,
watching.
kind of mercy petition, my lord. The petitioner was already convicted by the court below, my lord. And
Terminated or convicted?
convicted, my lord. Convicted, my lord, no, Lordship will find that conviction order, my lord.
What do you want? This is for the first day, so we'll issue notice.
Yes, yes, notice may be issued, my lord, at this time. Yes. Otherwise, Lordship can, if the PP doesn't have an objection, when it can pass order. This is kind of mercy, my lord. Lordship definitely, my lord, is non-comfortable and all that. Court has also convicted. The only ultimate thing that this will
We'll not reduce it like that, we'll have to.
yes.
Issue notice. Yes. Heard Mr. Pritam Tafo.
Yes, my lord.
Learned counsel for the petitioner stop also heard MS
El Hage,
and
Hage, HAG.
so and so learned APP for the state respondent. Stop. This is an application under section 482 of the RPC 1973 for quashing and setting aside of the judgment or judgment and order dated 14/12/2023 passed by the learned chief judicial magistrate SEPA East Kamang district AP in GR case number 21 of 2023. SEPA police case number 18/2023 registered under section 380-457 IPC. Stop. Issue notice. Returnable 1 week. List, no formal notice because people is represented, and list after 1 week on a date to be fixed by the registry.
Obliged, my lord.
May I please, Your Lord?
Yes.
I'm moving an application under 39.
Mr. Kalita, this is 3048.
No, Your Lord, 30, A was initially, the case was recorded under 308 and 279. And
Then
subsequently on an application,
Added.
added.
302 added.
302, 201.
All right,
120B.
CD.
CD may be, no, your lordship, this has already charge sheeted case.
Okay. So the LCR will be.
LCR, scan copy of the LCR, your lordship.
When do you want it, Mr. Kalita?
17.
Call for the LCR from.
Scan copy of your lordship.
Scan copy of the LCR from the court of,
Sessions District Court, UPR.
got it, Tiyama? So and so, stop, list this matter on
13th of May.
13/5/2004.
Much.
Yes. Who's appearing in item 4? None appears for the petitioner when matter is called. You are for the petitioner?
Yes.
Additional affidavit has been filed?
Lordship, the respondent has to
No,
take the
see,
adjournment today, so
this court is not concerned with who is going to take adjournment. As per the last noting of the registry, it appears that petitioner was supposed to file an additional affidavit and respondents were supposed to file an affidavit in opposition. Has that been filed? A simple question has been put to you. You must be knowing, have you filed your additional affidavit?
no.
And
Your
what
Honor,
about the AO?
I'm appearing on behalf of the standing council.
Yes,
Mr.
what
Tabatani.
happened to your AO? Are you filing or you're not filing?
Your Honor, we are waiting for the parents reply from the department. Your Honor.
How much time?
4 weeks. 4 weeks.
No, 4 weeks. We are giving you 2 weeks. You file it. You have taken a lot many times. Since May 2023, you have been taking time for filing counter affidavit.
Your Honor, recently the standing council was changed, Your Honor.
All right, last
So-
chance.
Obligation.
Item number 3, as prayed for by Mr.
Uh,
Number 4, Lordship.
4
Sorry, 4. As prayed for by Mr.
H tie.
So and so learned counsel for respondent number
Respondent number 2, 3, and 4.
2, 3, and 4. Let this matter be listed on after 3 weeks on a date to be fixed by the registry to enable the respondent to file the counter affidavit in the matter. Stop. In the meantime, petitioner may file the additional affidavit also.
Gradually.
Yes. What some accommodation was sought in this matter? Yes.
Yes, Lordship, we are the central government, they are supposed to file their affidavit.
There is an order of 15th June 2022. Some decision. Who is supposed to file affidavit in opposition?
Lordship, respondent number 1 and 2.
Have you
Central-
filed?
Central-
No, my lord.
The 2022 matter, why so much time is being taken to file the pleading?
On several occasions, we made a communications to these respondents, my lord, the
All
respondents.
right, we'll give you time today as a last chance, so by the next
Fine.
date, ensure that the necessary affidavit is filed positively.
My lord,
It's an old matter, so let's not keep this matter hanging. And I think you are having some interim order?
No.
Mr. Your name?
M. Kato,
M. Kato, learned ASGI,
DSCI, my lord, Deputy Solicitor.
DSGI.
My lord.
Mr. M. Kato, learned DSGI, pray 3 weeks' time for filing the necessary affidavit in opposition in the matter. Stop. It appears that on several occasions, time has been given to the respondent to file their return. However, the same has not been filed till date.
My lord.
Be that as it may, as a last chance, 3 weeks' time is given to the respondent to put their affidavit in opposition on record, failing which the matter shall be considered on merit. Stop. List the matter after 3 weeks on a date to be fixed by the registry.
My lord. Deeply.
3, 4, and 5. Where will you file?
You are for respondent number
1 and 2, my lord.
1 and 2.
So that maybe is.
And also make a note that for respondent number
3, 4, and
3, 4, and 5, affidavit in opposition is already filed. All right.
Deeply.
8. Yes,
My lord, I'm appearing for the petitioner, my lord. In fact, on 10/1, this is a
it's a civil revision.
civil revision. This regarding some,
Some ex parte order has been,
yes, my lord.
you are challenging the order dated 9/10/2023,
My lord.
passed in IA,
Yes, my lord.
whereby the proceedings of KEBA was interfered.
Yes. That was in a LA case, my lord.
Your notice has not been issued.
Notice issued, my lord. In fact,
Who is appearing for the other side? No one present today?
no one present today, my lord. Otherwise, they filed their affidavit and on 10/1/2024, my lord.
You are appearing for the respondent?
Yes, my lord. Yes, my lord. I'm appearing for the respondent.
Yes, which is the order? Let's go see the order
My lord.
that is under challenge.
My lord, the impugned order is at page 118, my lord. 118.
Page 118. Yes, please.
My lord. Order starts from 119, my lord. This application is taken up today as unlisted on being mentioned by Mr. So-and-so, learned advocate for the applicant Srimati so-and-so, who is the respondent herein, my lord, wife of late so-and-so. By this application, applicant prayed that an interim order may be passed by suspending Kaba Parwana dated 5/9/2023, issued by one Sri Orken Jine, in charge head Gaubura of E Village, West Siang district. Mr. Ete submits that after the demise of applicant's husband, a dispute with regard to the distribution of properties arose, because of which a family sitting took place on 16/7/2023. But due to the absence of necessary parties, decision could not be, in fact, it should be could not be arrived on that day. Therefore, having no other alternative, The applicant, who is the wife of deceased, filed a letter of administration application before this court on 26/7/2023. Accordingly, notice was issued to respondent, including to one Sri Yomto Jini, presently residing in so and so. In response to the notice, respondent Sri so and so has also filed his objection in the LA petition before this court on so and so. However, when the matter is pending before this court for hearing and final decision, the impugned Kaba Parwana dated so and so is received from the head Gaonbura of E village, directing the applicant to appear in a Kaba at E Kabagar, scheduled to be held on 17/10/2023 at 8 a.m. The said Parwana is issued on the basis of complaint lodged by Sri so and so for the settlement of disputes of the properties of late so and so. Mr. Ete submits that when the matter is pending before this court and is sub judice, Kaba should not have issued the Parwana to conduct a Kaba on same subject matter between the same parties. Therefore, so and so prayed that the head Gaonbura may be restrained from deciding the dispute, which is already pending before this court for decision.
So basically, it's because the case is pending in the court, the Kiba proceedings have been suspended.
Yes,
So what is wrong in this order?
my lord, wrong is that, my
And
lord,
what has happened to the, to those proceedings?
my lord, this order was,
What
otherwise,
happened to the proceedings before the district court?
That has
Come
been
on.
stayed by this honorable
Those
court.
proceedings are under stay.
Yes, ma'am. Still on it.
Is there a stay order?
no, yes, my lord,
There is no-
this order has been stayed, my lord, otherwise, but the Kaba could not, have not been held, ma'am.
You are for whom?
I am for the petitioner.
You are for the?
Yes, revision petitioner.
Revision petitioner.
Yes.
You wanted the Kiba proceedings.
Yes, ma'am.
Correct?
Yes, ma'am.
And before the district judge, the other side
Yes.
has obtained an interim order
Yes.
whereby those Kiba proceedings have been kept under suspension, correct?
Yes, ma'am.
That order you assailed by way of a revision before the,
Ma'am.
before this high court.
My lord.
And in this proceeding, you obtained a stay order.
Yes, ma'am.
Stay of what?
Stay of this order.
Stay of this
Yes,
order.
ex parte order.
But what happened to the proceedings otherwise? The
This-
proceedings are not stayed, proceedings before the district judge.
This, yes, it is going on, ma'am.
Going on.
LA,
What is the status?
status. Okay.
It's fixed on 15th of May, whereby they have filed another application for amendment of the petition, which is, and we have prayed for the reply, Your Lordship. There is another petition where we had also prayed for filing an additional affidavit, where in the first Kaba, where the dispute was already resolved, Your Lordship, the execution has also been done, Your Lordship.
There is already a first Kiba proceeding. where
Yes.
It has been resolved.
Yes, Your
Issue
Lordship.
was resolved.
Yes, Your Lordship. And therefore, subsequently, they have filed this LA, Your Lordship. It's in the LA where
Subsequently, they filed LA. LA means
letter of administration, Your
letter of
Lordship.
administration. And this is under what provision?
A Succession Act, Your Lordship. Our Kaba was as per the AFR, Your Lordship.
All right, but since the subject matter in the present revision petition
No,
is the order dated, is this order
9/10/2023.
10,
2023, yes.
20,
23.
23? So here, the only thing is that the court noticing that the entire issue is pending before the High Court,
Right.
they have suspended the Kiba proceedings. So what
Right.
is wrong in that order?
My lord, wrong as in, my lord. Firstly, my lord, that in the LA case, my lord, the title is not decided. Title, your lordship knows, my lord, under the Kaba, the village authorities have been given the
This court
power.
doesn't know anything. You have
My
to
lord.
enlighten this.
My
court.
lord, my lord. Under the,
Yes.
my lord, Assam Frontier Regulation, my lord.
And the,
Assam Frontier Regulation, my lord. The Gaonburas have also been, the village authorities, my lord, they are otherwise called as Gaonburas also, my lord. They have been empowered to decide civil suits, my lord. Suits
under
of
what provision?
disputes of civil nature, my lord. This is, my lord, the
Yes, regulation,
this is Assam Frontier Administration of Justice Regulation,
yes, regulation,
1945.
which is the regulation that you are relying.
My
where
lord, it is
government
at
has been given the
Page 40, my lord.
Yeah,
Page 58, my lord, that internal page 58, section 40, my lord.
yes,
The village authorities shall try all suits without limit or value in which both the parties are indigenous to the state of Arunachal Pradesh.
So this is the power of the village authority.
Yes, my lord.
Yes.
So, my lord, why?
Now, bypassing this power, a LA case was filed.
LA case, my lord, it was filed under another act, my lord, that succession act, my lord.
Hmm.
And what happens is the LA case, my lord, LA case, in a LA case, my lord, the title is not decided. Whereas the village authorities, my lord, the Gaoburas,
So according to you, since the title is yet to be decided, the LA case is premature. First, the title has to be decided. Is that your case?
no, my lord. In the first kaba, already the village authorities, the partition, divided the properties, my lord.
Where is that order?
My lord, that is at page 11, my lord. Page 11, my lord, the translated is at page, oh, my lord, sorry, my lord. It is at page 24, my lord, page 24. Page 24 of my petition.
Page 24, yes.
And translated, my lord, this is in the local language, my lord, dialect, my lord.
Yes, page
Translated is at
26.
page 26, my
26.
lord. Meeting minus Jinu Kama decision on dated so and so,
This
Srimat.
is title over a shop,
Yes,
property shop.
it's a plot of land, my lord, where there is a structure is
shop.
there, my lord, RCC structure is there. So and so has submitted a complaint before Jini clan on so and so. The soap that my late father-in-law had given is not being handed over by my mother-in-law, Srimati so and so, so and so. That the thatched kitchen was built by Sri Yomto Jini today on 16/7/2023 under chairmanship of Sri Hendak Jini, GB, at the residence of Sri so and so, late so and so. Jini clans on adjudication of the above complaint has given the following decision. In regard to the point number 2 of the complaint, it is hereby decided that the thatched kitchen shall be given to Sri Yomdak Jini in memory of late Rayam Jini. In regard to the point number 1 of the complaint, with regard to the partition of the commercial building, the order is passed as such that the partition shall be as per the partition made by the deceased father. It is hereby passed that the upper part of the partition building shall be passed in favor of Srimati so and so, wife of so and so, and the lower portion part of the partition building is passed in favor of Sri so and so, the petitioner, Yomto Jini. This is how, my lord, the Kaba divided the property.
So partition is made and upper part is Dongam Jini.
Yes.
Dongam Jini is the respondent.
Respondent here in the
And respondent and the person who had applied for the kabang.
no, my lord. Dongam Jini, my lord, I had applied, the petitioner in the CRP had applied.
And they had filed the LA.
Yes, they filed the LA before the district judge. After this, my lord,
All right.
after
And the lower portion in favor of Yomta Jini. That
Yom-
is
Yomto Jini is the petitioner,
is
my
the
lord,
petitioner and the person who had
Initiated
approached
the-
before the
village authority.
village authority.
No.
Yes,
My lord, this was passed on 16/7/2023, my lord.
yes.
And as per that AFR, my lord, an appeal, if any party is aggrieved, they have to prefer an appeal within 30 days, man.
Under which provision, regulation?
Regulation, man. It's 45, my lord.
Yes.
My lord, this 45(1), my lord. Unless any party having a right of appeal against a decision of a village authority gives notice when such decision is pronounced of his intention to appeal against it, the village authority shall carry out the decision forthwith, and for such purpose,
That is giving a
Ye-
notice.
yes, my lord. That's my lord, second, my lord.
Yes.
Execution and enforcement of the order or the decree passed by the, if the person against whom a decree or order has been passed by the village fails to pay or comply with such order or decree within a period of 30 days, the party in whose favor,
This is for
yes,
execution.
execution, my lord.
But where is
So
the
we-
appeal provision?
it is within this only.
Appeal has to be under what provision?
Appeals from village authorities, my lord, at page 24, my lord, section 24.
Regulation 24.
Yes, ma'am.
Yes, appeals.
Any party agreed by a decision of a village authority
Very
may,
good. So there is a
24.
appeal provision. If you do not appeal, then execution.
yes, ma'am.
Yes. Now
execution.
what happened?
But they did not prefer any appeal,
They
ma'am.
have not preferred an
Preferred
appeal
any.
against the partition dated 16/7/20.
Yes, ma'am.
Yes, then
Instead, they filed this
we filed the LA.
LA.
What is the relief in, where is the LA here? Application is part of the paper book,
Yes, my lord. It's a part of this application.
Yes,
It
where-
starts at page 30, my lord.
page 30.
My lord. Starts at page 30, my lord.
30.
Yes, my lord. 30, my lord.
Yes, what has they prayed here?
Prayer, my lord, prayer portion is at page 4. Prayer is at page 36, my lord. In view of the aforesaid
One
facts,
letter of administration.
yes,
In
ma'am.
respect of the entire property.
Particular, yes, that
In
building,
respect of the entire property.
Yes, ma'am.
Which was already,
subject matter of the Kaba, ma'am.
in which there is already a partition.
Yes, ma'am.
Isn't it?
Yes, ma'am.
So the first Keba has already made a partition in respect of this property.
Yes, ma'am.
And in respect of the same entire property, now they want a letter of administration.
Yes, ma'am.
This appears to be not correct, then how can you have this entire property? Because there is already a partition order and you've not put that to challenge.
Yes, ma'am.
Under the regulation, it is the village authority who shall decide the title.
Ma'am.
The village authority has decided
Ma'am.
and you have not filed any appeal against it.
Yes, Lord.
Then
Lordship, if we consider the page 24, the first cover, Lordship.
and why, what was the second?
My lord, second Kaba was because the second complaint I had lost, my lord. It was because this respondent, my lord, was not allowing me to collect the rent, my lord. The first Kaba, my lord, it has not been put to challenge, my lord. It has been,
So because of that, you had applied for holding a Keba.
yes,
Keba is a meeting, right?
yes, Kaba is a meeting.
It's a
Yes,
meeting by the village authority.
my lord. So I had said that I am not being allowed to collect the
Rent in respect of the property
Yes.
which has been
already divided by
given in
the,
favor of you.
yes,
By the Keba
My-
village authority.
my lord.
But this only problem is this revisional thing that you have filed is against an interlocutory order.
Yes,
Is a
ma'am.
revisional application maintainable against an interlocutory order?
My lord, here, my lord, because the order, my lord,
Have this decision.
my lord.
Singh versus Shashi Verma. TEK, Take Singh. The revision petitions filed under 115 not maintainable against interlocutory orders. You look into this aspect.
My lord. My lord, take Singh, my lord.
TEK,
Take him.
Take Singh
My lord.
versus Shashi Verma, SHASHI. The citation here is LNIND 2019 SC 101. Let's just find out. We can have this matter day after tomorrow if you want.
My lord.
You look into that aspect, whether,
My lord.
because the order against which you have filed this revision
Yes,
is otherwise an interlocutory order, correct?
my lord.
Where they have refused to, by which they have passed an interim order.
My lord.
That is the order that you are challenging.
Yes, ma'am.
So just see whether it is maintainable.
My lord.
And respondent side, you be prepared.
Yes, Lordship.
This court would otherwise dispose this matter on the next day.
My lord.
List day after for further hearing.
My
Duly okay.
This. Who is appearing in item 9? Affidavit has been filed by R6.
Yes, Lordship, that's me.
None appears for the petitioner when the matter is called. Stop. Respondent number 6 has already filed the affidavit in opposition in the matter.
Lordship,
Stop. List this matter after 4 weeks and a date to be fixed by the registry.
Lordship.
Number 11. Yes,
No, this is a anticipatory bail petition, my lords. I have already been granted interim relief,
or on interim.
please, my lords. 21st of December,
20.
please, my lords.
I'm putting informant complaint and
You are for the informant.
yes, ma'am. We have filed objection.
Have they appeared? APP? Yes, they have appeared?
They have appeared, your lordship. However, the check that was forged, your lordship.
The main check is?
The check that was forged, your lordship.
Ah.
The police could not obtain it, your lordship.
Not recovered. yet.
Not recovered yet. And therefore, though charge sheet was filed, a supplement, prayer for supplementary charge sheet, though the charge sheet was filed, a prayer for supplementary charge sheet was made, your lordship.
Charge sheet is already filed here.
Yes, your lord.
And supplement, you are going to file a supplementary charge sheet.
Yes, your lord.
But investigation then appears to be almost completed.
Almost completed, your lordship. However, because the main source itself is the check, your
The
lordship.
check is not yet.
Yes.
Where is the FIR?
Lords, page 27 annexure P1. Lords, only clarification, it is a
20?
27 annexure
Yes.
P1.
You are Mr. Tama,
Lords, I am Anshuman Sahni.
Anshuman
Sahni.
S.
Sahni.
Shani.
Please, my
Yes,
lords.
Mr. Shani, the FIR is at page
Lords,
30.
the complaint is on page 30, my lords. FIR is on 27. Lords, the complaint reads, and just to clarify, my lords, it is not a check. There is a power of attorney. Because the allegation against me is made by a third party. And the background of the allegation is, my lords, the petitioner herein and the son of the informant have been business associates and business partners, my lords. They have been in the business of supplying and manufacturing and distributing liquor, my lords. And the allegation is by the mother of the business associate of the petitioner, by the mother of the business associate, my lords. And the allegation is that allegedly I had forged a power of attorney in the name of her son, submitted it in a bank account where he was made the bank operating in charge of the account. And that was not to the knowledge of her or her son. That is the pure.
Who are you?
Lords, I am Sunil Kumar Bhardwaj. My business associate is Dorji Funso
You are not a
Khilme.
banker.
No, my lords. I
You are
am.
you are.
Please, my lords.
Yes.
The petitioner, Sunil Kumar Bhardwaj and Dorji Funso Khilme are business associates, my lords. And the FIR or the complaint has been filed by the mother of Dorji Funso Khilme. So, third person has first filed the FIR. Because the FIR was filed alleging that I have forged a power of attorney in the name of her son, making him the KYC in charge of a bank account by the name of Best Wholesale. Now, to that extent, my lords, the investigation has been carried out. The two dates in the FIR are very relevant to note. 24th of March 2022 and 11th of August 2022. Lords, on 24th of March 2022, I was not in India. I was in Dubai. I've submitted my passport details. On 11th of August 2022, I was in my native village in UP, Bulandshahr, where my real brother was on his deathbed and unfortunately passed 2 days later with cancer. Well, this investigation has been completed to the extent saying that I have had nothing to do with submitting or making the power of attorney or even submitting it to the bank as such, my lords. And there is a second, my lords, allegation which, clarification which I have also given, that since we are business associates, we have always known of who's working what and how things are working. And at the end of the day, my lords, they are in control of and in charge of the account Best Wholesale Limited. Till today, my lords, they are running the account, the complainants, the informant and her son-in-laws, they are still in control, still in charge of the account of Best Wholesale. So therefore, a criminality charge against me on that ground would not suffice, because the allegation is that the informants are not aware of this account. The informants don't know what is happening.
Miss, counsel,
Yes, Your Lordship.
this is the AP.
Yes,
Please, Your
yes,
Lordship.
Your
They've
Lordship.
already been interrogated.
Yes, Your Lordship. However, yes.
So custodial interrogation, I don't think is necessary.
In fact, we were not even taken into
necessary
custody, my lords.
because they are cooperating.
Yes, Your Lordship. The only concern is they're not cooperating, Your Lordship. There are statements of the employees who has clearly stated that the check was taken
Check,
by
what check?
the original check that has to be sent for FSL, and thereafter the who had forged it would be revealed, Your Lordship.
Where is it mentioned about the check?
Your Lordship, in the FIR itself.
Because what has been submitted on behalf of the petitioner, it is a PO, a power of attorney.
Yes.
Even the
Which is
FIR
alleged to have been forged by the petitioner while submitting KYC. Correct? This is what, so what check are you submitting?
From the
Adib,
account, madam, all saying everything has been transacted by him, madam. And now the deputy is there, no transaction has been made by him, madam. From the record,
See,
it transpired.
Whatever, it appears that these are disputes between the two associates.
Please, my lords. Please, my lords. And
And
my lords,
madam, the two associates, madam. And they are saying that, madam, the son of the madam, the informant complainant is the business partner, not exactly, madam. There is
Whatever, these are disputes between the two business partners, correct? So, criminality, maybe there, may not be there at this stage. This court will not go into that aspect. But be that as it may, what this court is concerned is about the custodial interrogation of the petitioner, right?
yes, sir.
Now, is that necessary? Because the petitioner has already, he has appeared before the IO and
Please,
he will cooperate, he will appear as and when he is required,
correct.
and my lords, all the information in my control has already been provided. Apologies.
right?
Yes, Your Lordship.
So to that aspect, I don't think further custodial,
Madam, may I-
yes, yes,
There's one record, madam.
yes.
This privilege of pre-arrest bail will be not entitled to him, is because madam, on so many occasions, the documents has been forgery, forged, and the signature has also been made. Before this honorable court also, madam, the affidavit, madam, before this, by which, madam, today, the petitioner is claiming for the, madam, the pre-arrest, privilege of pre-arrest.
Where is that affidavit?
Madam, may I take the lordships too? The affidavit filed by the, madam, the petitioner in his bail application, page
Yes.
number 26, madam.
Yes.
Madam, this has been filed on oath.
Yes.
Married, madam, particular, madam, oath, that I do hereby declare that this declaration is true and correct, and that it conceals nothing, and that no part of it is false, so help me God. Madam, affidavit has been
Chapra.
sown at Safra.
Huh.
When he was inside the judicial custody at Safra, madam, Bihar police station, Bihar.
Huh.
He was
And notary at Papumpara.
notary at Pap.
How?
Exactly, madam. This is the, madam,
How
the
has
force
that been
done
done?
by the, madam, serious, this is a, madam, my friend, madam, the registry may be directed to, madam, the inquiry again, and the another, madam, the fresh FIR may be lodged against, madam, the legally accused person.
Yes, Mr. Saini, how this affidavit has been sworn in at Papumpara when you were at Chapra?
My lords, just allow me a minute, my lords. No, it has
See-
not been done so. No, my copy does not show any such.
No, your
Yeah, I'm-
copy, because your copy, maybe the notary is not there. In the court
Yes,
copy,
madam.
the
Therefore,
notary is
madam,
there.
Madam, therefore, I had to obtain the copy, certified copy from this noble
You
court.
see, I don't want to say this, but many times, things are sent by courier and things are done, but it cannot be done like this. If
No,
this
then,
affidavit is signed at Chapra is where? In UP,
Bihar.
in Bihar.
Yeah, please.
Then the notary officer from Bihar should have,
Correct.
notarized.
No, this notary has been already done, my lords. They see the stamp at the oath place, my lords. It has already been done.
What is this then? What the requirement is there? When the filing was done, because as you looking on. Yes, Mr. Bhatia.
So when it was done, the state of Bihar had said, after filing lordship, while it was passed and while checked for defects, my lord, and then, my lord, it was come into the force by the Guwahati High Court rule, that even though this was notarized there, as the petition was filed here, all the other annexures, those were lordship, were certified by the local council.
Affidavit
And those
particularly for-
annexures were done by the local notary over here. And this affidavit, on the basis of the jailer's endorsement, as well as the notary.
See, Mr. Vaidya, I probably am following what you're saying. I'm sorry, I'm cutting you short. But see, the identification is done by one advocate's clerk,
T. Dodo.
T.
Dodo.
Dodum. This person must be from here.
Here.
Now,
He's
he
back.
has not seen the person signing.
Exactly.
Now, this affidavit probably has to be complete and sent. There would have been no difficulty, right? But the identification appears to have been done here, number one. Number two, all right, there is a notary signature there, so this court will take that into account and say it is notarized. But what about this identification? It's a part of the affidavit, isn't it?
Yes.
How can someone here identify? We have not seen.
Milord, the objection was raised by the registry. Milord, this was signed and approved in the jail in Bihar. So the notary in Bihar has approved and signed it. Even the jail authorities have signed it and sent it. But Milord, the objection was raised here that an identification has to be put here and need to be noted.
Anyway.
So Milord, due to
You see,
that
Mr.
objection,
There is already a notary officer who has notarized from Chapra. We take this.
Milord, even the jail
affidavit to
superintendent
be valid.
has.
Much higher stakes are involved in this petition. It is the life and liberty of the petition. This court will not go into these technicalities now. Because if this notary seal was not there, it would have been another thing. But this court would have been with you. But since there is already, it has been notarized from Chapra, so that is already. Any other objection?
No, my lord, that is my lord, my first objection, my lord, first limb of objection. My lord, the second limb of, my lord, again, my lord, I'll come to this affidavit, my lord. This is a completely false, my lord, the affidavit, my lord.
We are not getting into the merit. You see, this court's exercise is only to ensure that the petitioner appears during trial. This is the whole object of bail, correct? Now, do you have anything to say that they will be absconding, that they will not be appearing? You cannot say that. That is for the state to say if the state has anything on record from the IO. These are the factors which has to be considered during the stage of bail. We are not on the merit.
Madam, admittedly, that is the, madam, the whole proposition of law, madam. Madam, here, madam, when he realizes the pre-arrest bail will be entitled to him, madam, when he comes before this honorable court with clean hand mind, and mind. Madam, the height of the forgery is not only seen from the, madam, the original case record. And the height of the, madam, the forgery is apparently, madam, done even in this bail application. And when the person was inside the custody of the Bihar, some other state, and seems to be appeared before this notary officer, and identified by one of the colleague. It is not the mere the procedural mistake. This is a serious the mistakes done by the petitioner. So therefore, this is.
You have taken this ground on your.
Admittedly, we have noticed these things on the later stage.
So they are not on affidavit?
Affidavit, we have not trained. That's why we have obtained.
No, you see, because if you don't put them in affidavit, they will also not be able to explain.
And this is the my.
Can this, let me pose this matter day after. In the meantime, you file your, what objection you want to file as regards this. and give them a copy tomorrow. By day after, you file your reply. You want it day after or on Thursday, Friday?
Lords may have it next week
All right,
and
next
may
week.
give me permission to appear through VC, my lords.
Yes, yes.
I'm
You
traveling
don't need
from-
a permission nowadays. There is a link provided, you simply,
Yes.
possibly if someone from local is also there, it
Please,
will be
Lords.
better
They'll be
because
there.
you see sometime
Lords, we'll ensure that.
coordination becomes a problem.
We'll ensure that. And Lords, if I may suggest, my lords, may even ask the registry to send the defect list, because my lords, this was raised in the defect very clearly, and that is why this was done, my
So,
lords, on the
there was some
instruction.
defect raised.
Please, my lords. And it is on the basis of that that this has been done additionally, my lords.
Then, madam, that cannot be
And-
corrected this way, madam.
No,
One
what
is
has been
clear.
corrected?
The correction, madam, we are also from.
No, there is no correction here in
Yes,
this
madam.
affidavit.
Yes, madam.
What correction are you talking?
No, madam, they are saying that, madam, this is the correction done by them at the registry, not exactly, madam.
What was the defect that was pointed to?
Yes.
Vidya?
It is there where that the affidavit was done notarized outside that is the jurisdiction of this honorable court. And if that be the case, my lord, then all the pages of the petition as well as the connected annexures
Need to be
they
notarized.
require to be notarized.
Okay.
So generally what happens, lordship, as per the Guwahati High Court rules which govern these proceedings, the affidavit is notarized and the petition is notarized and the annexures, they are required to be notarized by the counsel who is filing the petition before the honorable court. But lordship, in addition to that, as and when the case, when the affidavit is notarized outside the jurisdiction of this honorable Guwahati High Court, then lordship, all the annexures need to be notarized. So that is why lordship, the rest of the annexures, those were notarized here in my lord.
This objection was raised from here.
Lord, from here, my lord.
Lords, if I may only submit in lighter vein, it seems the affidavit is more fortified than And my lords, just to
Wait
highlight,
for some time.
Yes.
Let me call the registrar.
Please, madam.
Maybe there will be-
and my lords, just to highlight, this takes away from the
Let us
case.
just have the view of the registry as what is this.
Please, my lords.
And if our affidavit is further required, we will post it on another date, or otherwise we shall consider the case right away.
Please, my lords. Deeply
Just
obliged.
wait for some.
My,
Please.
Who is appearing in item 12?
The council was the council was from the Assam, your lordship.
Case diary is available.
No, your lordship.
No.
No, in-
Await case diary, list this matter
on 6th of May.
on 6/5/2024. Stop. Since petitioner is not represented, registry may intimate the learned, Ms. T. Das, learned counsel appearing on behalf of the petitioner as regards the next date of listing.
Deeply.
Yes, 341-307 CD,
Here also case there is still awaited, lordship.
not available.
No, lordship. By
Await
tomorrow,
CD, list on,
by tomorrow, I'll try to bring it, lordship.
list tomorrow,
Lordship.
Okay, Your Honor.
tomorrow,
in-
day after tomorrow.
To may I be tomorrow. Your Honor, in this case, there are total 6 number of accused persons here. Out of 6, 4 have been released by the district and session court. UPN. Out of 6 accused persons,
Huh.
4 have been released by the district and session court UPN, and only
Tomorrow.
remaining 2.
Tomorrow, list tomorrow, you have the CD and you have the other orders. Tomorrow.
Okay,
Oblige.
I will oblige you. It's same, Your Honor.
Same
Same, lordship.
Same.
Out of same, I file, lordship.
tomorrow,
Oblige.
15.
Number 15.
This, here also, I think, a fill-in from Guwahati,
Yes, your lordship.
G. Gogoi.
He go good.
CD there.
CD is there, your lordship.
None appears for the petitioner when the matter is called. Stop. Is the petitioner on interior?
Yes, your lordship.
Case diary call for is available. Stop. Let this matter be listed
On 7th.
on
7th of May,
On
7th.
7/5/2024, stop. Registry to intimate Mr. D. Gogoi, learned counsel for the applicant as regards the next date of hearing.
Deeply.
List accordingly.
Meanwhile, your lordship, in item number 15, updated CD may be called for in that. Deeply.
During the defect period, lordship, when my colleague were done the filing copy of the we definitely were not insisting, lordship. We had got a notice from Bihar and the superintendent of jail had endorsed it. Then subsequently, my lord, this was done here during his filing, my lord. Then probably the defect list probably. One thing if I may, lordship, for the very reason, because for a document to be notarized, the deponent has to be in front of the person or the notary who is notarizing the document. That is the very reason, lordship, that we took the pain that a notary be called to the jail in Chapra, because that is the procedure, lordship. That is what we adhered to.
Please, Lord.
Now, we added, there is another notary that because of the slide.
Maybe, lordship, but I believe there's no malafide on the part of the petitioner with this regard. Maybe some procedural, maybe double, it has been done, my lord. But there's no malafide or no one is to gain anything, my lord, from this. We are not to gain anything from this, my lord.
Please, my lords. It is page 27 in Annexure P1 and the complaint is at page 30, my lords. 27, my lords. P1 annexure, that is the police recorded FIR, and the complaint is at page 30, my lords. Please, my lords. Please, my lords. Lords, first information report against Sunil Kumar Bhardwaj and Debashish Ghosh. Lords, this petition is only on behalf of Sunil Kumar Bhardwaj. With due respect, I am to state that on 23/12/2022, my son, namely Dorji Funso Khrime, had informed me that one Shri Sunil Kumar Bhardwaj, son of Kalyan Singh, resident of Bulandshahr, Uttar Pradesh, and Debashish Ghosh, son of Jatin Ghosh, resident of Bhilpura, Assam, had made a fake power of attorney between Shri Kani Burang, proprietor of Messrs Best Wholesale, and my son without his knowledge, consent, and had been operating one bank account in the name of Messrs Best Wholesale at Punjab National Bank, Naharlagan branch, representing himself as my son. Accordingly, on 31/12/2022, I went to the bank for inquiry along with one Shri Mindak Karcho, and it came to my knowledge from the bank manager that in the year 2017, Shri Sunil Kumar Bhardwaj had opened one current account in the name of Best Wholesale bearing number so-and-so and operated the same till 24th March 2022. Thereafter, on 24th March 2022, Shri Sunil Bhardwaj and Shri Debashish Ghosh submitted one power of attorney in my son's name in order to change the KYC of the account in Messrs Best Wholesale, of which my son had no knowledge. And since then, account holder name was changed from Sunil Kumar Bhardwaj to my son's name. However, on 11/8/2022, Shri Sunil Kumar Bhardwaj and Debashish Ghosh came to the bank and requested the bank manager to close the said account at the earliest. Thereafter, I discussed with my son regarding the same, and then he told me he had no knowledge about any power of attorney for Best Wholesale, never signed any papers, and never went to bank for the same. It is clearly understood Shri Sunil Kumar Bhardwaj and Shri Debashish Ghosh had made a fake power of attorney between my son and Shri Kani Burang, proprietor of Best Wholesale, with intention of ill motive. Sunil Kumar Bhardwaj had forged my son's signature in the said power of attorney. Milords, Sunil Kumar Bhardwaj and Dorji were business associates. Debashish Ghosh used to be their employee, used to do a lot of their work for them. Please, Milords. Milords, they both have different entities, Milords, under which they operate. In fact, the petitioner operates in Himachal, and Milords, the informant's son operates in Arunachal, Milords, and they have agreements between them. No, this is the second. No, page 31 is the second agreement between the petitioner and the informant's son. That is not relevant to, Milord, the question that has been put. Milord, with respect to Best Wholesale, Milords, has licenses with respect to liquor shops in Arunachal Pradesh, Milords. The proprietor for this is, Milords, Shri Kani Burungs. Please, Milords. Well, that they have not so said in the complaint, Milords. Which is, Milords, of 24th of March 2022. This is the allegation, Milords. Now, Milords.
Your Lordship, the statement of Kani Bora, he clearly says that he does not even know. First, a power of attorney was made between Sunil Bharadwaj and the person, Your Lordship. Subsequently, the forged power of attorney, Your Lordship, he had no idea about it. However, his signature is... Yes, 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 Your Lordship. Yes, other than that, Your Lordship, with regard to custodial... Your Lordship, since the charge sheet has been filed, Your Lordship, and for the supplementary charge sheet, the CD was not called for, Your Lordship. So I don't have the status of if there is any objection to... No, Your Lordship. No, Your Lordship. On the last occasion, since the charge sheet was filed, Your Lordship, and therefore LCA was called for. The subsequently prayer for... No, Your Lordship. I don't have the updated case diary. I'll have... Yes. Yes, Your Lordship.
If I may only submit. Please, Milords, I'm on interim. I cooperated. I appeared before the IO. Milords, bail was taken. And whenever, Milords, I was asked for to... Please, Milords. Milords, would 2nd of May be suitable? Milords? Please. Milords, I just wanted to highlight one more aspect. Milords, the allegation is that they had no idea about the account. Milords, I've submitted bank statements from the account. Their transactions from their account to this account and to this account, from this account to their account. So, please. After second. Hold.
Your Lordship, since the entire police, Your Lordship is also well aware that there is repooling also.
On 6 months.
Please, Milords. 6th is obliged, Milords.
Just now, my lord, I'll check out with my lord, the High Court rules also, my lord, there is other provisions, how the things can be done. My lord. Correct. I'll come with it.
Lords, I deeply apologize, my lords. Sixth is a bit troublesome. My learned colleague also has certain. Lords, we'll just discuss amongst ourselves and inform.
On seven. Seven, let us make it on seven.
Please, please, my lords. Please, my lords. Deeply obliged, my lords. Deeply obliged. Deeply obliged.
May please, ma'am. Yes, madam. One, respondent one. Malo, this, malo, appearance was made, malo. That, my lord, I'm not aware.
Here, the SIC tender found in Mr. O. Father, we don't have a station.
On the last 15, on behalf of recorded number 2, however, the office note dated 24/24 indicates that no Wakalatnama has been filed in 15 days. Let registry to verify and place up-to-date status of record number. This is marked after completion and
My lord, here otherwise, basically my grievance is against the action of the SIC, my lord. So, party, yes.
We need further instruction.
The 2 week time is record number 1 to file the affidavit in the
With respect to the same FIR, this is a quashing petition. Because I think it's a procedural hearing. The service has been completed, my lords. The opposite side may file the reply.
This is also same connected to the first one, madam. In item number 11. My case diary may not be required because this is. For quashing of the mallet, this is basically for quashing of the mallet, the FIR. Correct. Yes,
Yes, your lordship. Oh, same date, your lordship.
Lords, may I only request, my lords, if they want to file a reply, because it's slightly. Lords, I think 2 and 3. 2 and 3. Lords, we have agreed to 3rd of May.
That of May is too long.
3rd of May.
May.
That of May.
Mm.
That of May.
Third.
That of May. That May.
Or second.
What of Mali?
Second.
Please,
Your
deeply
lordship,
obliged, ma'am.
your lordship, in item number 17, your lordship, I may just clarify, your lordship, that in this case, normally when the documents are produced in the CD, your lordship, and this, no, not LCR, CD was called for in
CD
item
was-
number 17, your lordship. So what happens is, if the affidavit is filed, the CD, which is confidential, is take along with the affidavit, and some of the accusers, sometimes it has happened in this court, your lordship, they apply for the certified copy. Since the CD is confidential, your lordship, the order that the affidavit they may file in affidavit. Item number 17. They are for the state, your lordship, special public prosecutor.
One, SIC. Otherwise, CD was called for. Lordship,
No, Your Lordship, we are yet to receive the extra copies, Your Lordship.
because of some miscommunication, we could not serve. Lordship, I'm within course of this.
So they're talking about ensure that the extra copy required to be furnished to the letter coming for the respondent and be furnished within the course of the day.
Yes.
And this is matter after 3 weeks of the day.
And Lordship, there is an interim order, definitely. Deeply obliged, Lordship.
Here also, Your Lordship, we need some more time to file our pair-wise comment, Your Lordship. Why Ram, Your Lordship? 5.
Online.
Number 21.
CD was retained on the previous occasion, Your Lordship.
Yes.
Yes.
I'm appearing for private respondent.
Yes.
My lord.
Application.
Ma'am. Hello. By filing this application, I am seeking cancellation of bail granted to the respondent number 2 by the learned executive magistrate SEPAM, noted in SEPAM PS case number 118 of 2023. Initially registered under sections 326, 120B, 506, and 34 of IPC.
Sections.
Initially registered under sections 326, 120B,
506.
506 and 34 of IPC. Madam, of all the offences initially charged against the respondent number 2, maximum punishment is provided under section 326, which is imprisonment for life. My lord is aware, section 437 of CRPC empowers the magistrates to grant bail in case of non-bailable offences. However, my lord, subclause 1 of subsection 1 of section 437 creates an embargo on the power of the magistrate. My lord, may kindly have section 437 for you. Yes, my lord. 437, may read below. When bail may be taken in case of non-bailable offences. When any person accused of or suspected of the commission of any non-bailable offence is arrested or detained without warrant by an officer in charge of a police station or appears or is brought before a court other than High Court or Court of Session, he may be released on bail, but such person shall not be released if there appears reasonable ground for believing that he has been guilty of an offence punishable with death or imprisonment for life. What diverges from reading of this provision is not.
If there appears reasonable ground for believing that he has been guilty.
What diverges is, my lord? Subclause 1 creates an embargo. A magistrate considering a bail application in offences punishable with death or imprisonment for life, he has to report his satisfaction that there is no reasonable ground for believing that
This is a bar like NDPS.
Yes, madam. Unless that satisfaction is recorded, my lord, the magistrate shall be deemed to have no jurisdiction to entertain a
Not
bail.
exercise.
Yes, yes. Now, my lord, coming to the facts of the case.
And so you are only under 1, no?
1. Coming to the facts of the case, my lord will find the FIR at page number 20.
1 second. Yes,
Page 20 is the FIR.
page,
20.
yes. Who is appearing for the other side? You are there? You are for the accused?
Yes, ma'am.
Yes. Yes, please read.
Merit. To the officer in charge, police station Cheppa, is coming district, Arunachal Pradesh. FIR against Sri Takam Dada, Sri Talam Dada, and Sri Pojum Dada. Pojum Dada is the respondent number 2. Resident of
Who is R2?
R2 is the Pojum Dada.
Kojun Dada.
Pojum Dada.
And Talam Dada is not before this court.
No. Okay. I'm seeking cancellation of bail in respect of Pojum Dada.
Only R2.
R2.
Yes, please.
It is to bring immediate notice before you that on 15/12/2023 at around 6 p.m. while my father Sri Logya Lambu was at his residence at Richi Lambu village, Sri Takam Dada attacked him with local sword stroke down with an intention to kill him, thereby inflicting grievous injuries on forehead and right hand of my father and fled away from this spot. Father, it is to apprise your good office that there was a dispute with regard to ownership of Mithun between Sri Takam Dada and my uncle, and the claim of the assailant was outrightly rejected by the victim along with other members present in the meeting 2 months back. Thereafter, Sri Takam Dada and his son mentioned above left the place, threatening my father, Sri Logya Lambu, and other members present with dire consequences. As such, Sri Takam Dada and his son has a conspiracy to kill my father, and in furtherance of their conspiracy, Sri Takam Dada came prepared today at my father's residence with intention to kill him. It is to inform you that Sri Kodam Dada, he was the one who intentionally insisted or conspired his father to kill and attack as and when me. Therefore, it is requested to your esteemed authority to get.
There is the order of the magistrate.
Then the impugned order, my lord, will find at page number 44. Annexure 9.
This is the order by which this person was granted bail.
Yes, ma'am.
Against this, you have filed.
This criminal miscase, madam, under section 439(2) for cancellation of bail. Yes, ma'am. Section 439 subsection 2. The High Court or Court of Session may direct that any person who has been released on bail under this chapter be arrested and commit him to custody.
And here, this is bail was granted by
Executive magistrate.
not session.
No. In respect of section 439(2), High Court and Sessions Court, they exercise concurrent jurisdiction.
No, that's all right, but you had this bail was granted under 437,
Yes, ma'am.
isn't it?
Yes, ma'am.
I'm sorry, but I have what is not clear before this court. The cancellation power, which is under section 439 subsection 2, relates to be under this chapter, right?
Yes, ma'am.
So 437 shall also come in.
Yes, ma'am.
because it is the same chapter.
Now, my lord, in the impugn order, while granting bail to the respondent number 2, the learned executive magistrate has not recorded that satisfaction to overcome that embargo. The respondent number 2 was granted bail only on 2 premises.
The satisfaction about the prima facie guilt.
Yes, madam.
That part.
Absolutely, my lord, silent. Relevant portion, page number 45.
Yes.
Paragraph starting with upon hearing. Upon hearing of IO, it is found that accused is not habitual offender. And
Yes.
he is already interrogated.
Yes, yes. Yes. Where is that satisfaction? Prima facie satisfaction is not there.
Yes, your lordship, if I may, your lordship. If I may take your lordship to the impugn order, your lordship.
Yes.
The page number 45, your lordship.
Yes.
If I may read the
Yes.
second paragraph, your lordship.
Yes.
Sub-Inspector so-and-so investigation officer represent and submitted that he has objected in enlarging the accused Shri so-and-so till the completion of the investigation. Learned PP so-and-so has fairly submitted to pass any order as deemed fit and proper. Heard the learned counsel for applicant, learned public prosecutor and IO and also peruse the record. Your lordship will see he has perused the record, your lordship. Upon hearing of the IO, it is found that the accused is not habitual offender and he is already interrogated by the investigation officer. This court is
Yes,
inclined
yes,
to
APP,
now.
have you seen section 437?
Yes, I was about.
If there appear reasonable grounds for believing that he has been guilty of an offense punishable with death or imprisonment for
Yes,
life.
I was coming to that.
Therefore, a prima facie satisfaction has to be seen.
Yes, your
Now,
lordship.
how can this court see whether this exercise is done or not?
Your
It
lordship.
has to be evident from the order,
Yes,
correct?
yes, your lordship.
Therefore, there must be some finding recorded
Yes, your
that
lordship.
there are reasons to believe that the accused is not prima facie guilty.
Yes, your lordship.
That satisfaction is not, it does not appear.
Yes, your lordship.
Simply recording peruse records will not do.
Your lordship will also see the proviso provided under 437, your lordship.
Yes,
The second proviso
yes.
provided further that the court may also direct that the person referred to in clause 2 be released on bail if it is satisfied
That
that.
is clause 2. We are concerned with clause 1.
Yes, your lordship.
Clause 1.
Also, your lordship will see that in that case, the fourth proviso, your lordship. Provide also that no person shall, if the offence alleged to have been committed by fourth proviso, your
Yes.
lordship. Provided also that no person shall, if the offence alleged have been committed by him, is punishable with death, imprisonment for life, or imprisonment for 7 years or more, be released
That is
on
the
bail by the
PP.
court under
You see?
without. Yes, opportunity
Yes,
was.
correct. That opportunity was given to the PP.
Yes.
Now, why is that opportunity given to the PP? Because only once the opportunity is given to PP, the PP can point out
Yes.
whether there is a case made out, whether there is a case,
Yes, your lordship.
whether there are materials.
Yes.
And on that basis, the court shall exercise the discretion
Yes.
in the manner laid in 437, isn't it?
Yes, your lordship.
But it prima facie, this order appears that there is no satisfaction generated.
Your lordship will see that even in the FIR, your
Are you
lordship.
supporting this order?
Yes, no, your lordship. I'm supporting the order, your lordship. The CD was called for your lordship. Because since the court has perused the CD, your lordship. Your lordship will see the main accused. Takam Dada, your lordship. He has confessed his, and the accused against the cancellation of bail has come, your lordship. He was not even in the station at that point of time.
So according to you, there is no case made out.
Prima
against-
facie,
Prima facie,
only
there is no case.
the reflection in the this has not been given, your lordship, for
But the CD, from the CD.
CD because
it's
perusal
given.
was there, your lordship.
No, where it is mentioned that this particular person against whom the cancellation is sought for, what is his name? Mr. Pojam Dada.
Yes, your lordship.
Where from do you show that there are no incriminating materials available?
The statement of the
Underline it.
this is the statement of the the main accused who is still in the jail, Your Lordship.
All right.
Your Lordship, also Your Lordship, if Your Lordship will see, the impugn order was passed by the executive magistrate. Why? Because the magistrate was out of station and therefore he has handed over the charge to the executive magistrate, Your Lordship. Now, executive magistrate, not though he is having the power of judicial officer, but Your Lordship is well aware he is not much of a having a proper knowledge in dictating, Your Lordship. And therefore that
Don't make these.
She can't make
submissions. Don't make such submissions. I am, as far as, you see, considering that there is no incriminating evidence, I am inclined, I'm not going to cancel the bail only because of that. So now don't make unnecessary
Yes.
submissions for which I will have to, these are, don't make such submissions in the court. You see,
But Malad will take note of one more. Yes, please. Malad, page number 46.
yes,
During the course of investigation, section 307 was added. This is the intimation letter dated 26/12/2023. If the learned executive magistrate has taken note of the materials in the case diary, he ought to have taken note of this factor also.
but this is against the accused person Takam Tada.
But offense was registered against 3%.
Anyway. All right. Heard. You are Mr.
R.L. Kungan.
Heard so and so, learned counsel for the petitioner, stop. Also heard MS so and so, learned APP for the state respondent, and Mr.
D. Shoki.
D so and so, learned counsel for respondent accused. For respondent number 2, stroke accused. Stop. This is an application under section 4392 of the code of CRPC, read with section 482 of the CRPC for cancellation of bail granted to the alleged accused person, i.e. Shri Kojam Tada, in connection with SEPA PS case number 118 of 2023, registered under section 326 120B 50634 of IPC, in bail application number 84/2023, passed by the learned executive magistrate, SEPA. Stop. Did I mention the order dated? By order dated 26/12/2023. Stop. The case of the petition, the case of the applicant is that the applicant filed an FIR on 16/12/2023 stating that on 15/12/2023 at around 6 p.m., while the victim was at his residence, one Takam Tada attacked the victim with a local sword with intention to kill him and thereby inflicted grievous injury on his forehead and right hand. And after attacking, he fled away from the spot. Stop. It is the further case of the petitioner that there was a dispute regarding ownership of within quote Mithun between Tagam Tada and applicant's uncle, and in a meeting which was held 2 months back, victim and others present in the meeting had outrightly rejected the claim of Takam Tada. Stop. It is the further case of the petitioner that two other accused, including the petitioner, was present at the place of occurrence. Stop. Accordingly, FIR has been registered against the said three persons, including the respondent number 2, i.e., including the respondent number 2. Stop. By order dated 26/12/2023, the Learned Court of Executive Magistrate, SEPA, granted bail to the respondent number 2 in bail application number 84 of 2023, filed under section 437 CRPC. Stop. The petitioner is challenging the said order of the Learned Court of Executive Magistrate dated 26/12/2023. Stop. Then you write, Mr. So-and-so, Learned Counsel for the petitioner submits that the aforesaid order of the Executive Magistrate dated 26/12/2023 granting bail to respondent number 2 under section 437 CRPC is erroneous inasmuch as there is no prima facie satisfaction recorded by the Learned Court as regards the guilt of respondent number 2. Stop. MS on the next paragraph. MS so-and-so Learned APP on the other hand, by producing the case records, submits that there are enough incriminating materials available against the respondent. There are no incriminating materials available against respondent number 2 for the offense alleged, and considering the aforesaid case records, the Court of Executive Magistrate order dated 26/12/2023 granted bail to respondent number 2. Stop. Right? Next, you say, Mr. So-and-so, Learned Counsel for the respondent number 2 submits that there is no infirmity in the order dated 26/12/2023 by which the Learned Executive Magistrate has granted bail to respondent number 2. Stop. He further submits that
My lord, that under section 439(2), my lord, the correctness of the bail order cannot be assailed, my lord. That has to be in an appeal, my lord. Under 439(2).
he further submits that the current application is not maintainable in terms of
assailing the order,
In terms of subsection,
439(2), my lord.
is in terms of subsection 2 of section 439 IPC, CRPC. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the Senate Court of Executive Magistrate TEPA has heard the sub-inspector, has heard the investigating officer who was present in the court, and has also, after hearing the public prosecutor, who has fairly submitted that there is no objection for grant of bail, pass the said order. Stop. It further reveals that the case records produced by the Office of the Public Prosecutor was also perused by the by the said court. Stop. The said case records has also been placed before this court, from which it appears that there are no incriminating materials available against respondent number 2 for the offense alleged. Stop. That being so, this court finds no reason to interfere with the order dated 26/12/2023 passed by the Court of Executive Magistrate so and so. Stop. The question of mental ability accordingly is kept open. Dismissed.
Okay.
No cost. Returned case records. I'll resume in 5 minutes. Yes.
I apologize, my lords, but with my lord's permission, if I may just mention item 11, my lords, interim orders may be continued. This is the anticipatory bail petition, my lords. It
In
was-
item 11, you have taken the order. Interim order, if any, shall continue in the next day.
It's deeply obliged. my lords.
Service report against the respondent notice.
Await service report in respect of R2.
Yes.
List after 2 weeks on a date to be fixed by the registry. Here, I think also service is not completed. AD card in respect of R2, anybody appearing?
No, not, that will come.
Await service, report in respect of R2.
Yes.
List after
My lord, it may,
3 weeks on a date to be fixed by the registry.
my lord, maybe fix on 29.
29, you want to
Yes.
fix it? All right,
Monday, my lord.
okay.
Much obliged.
Obliged.
22 and 24.
23, 24 also.
Same, my lord.
23 and
24,
24.
Same.
Okay.
Obliged.
You are Mr.
Tara.
Tara.
Yes.
Yes. And who's for the respondent?
I'm appearing for this.
You are?
Deepangi.
Mr.
Deepangi.
Yes.
No, my lord,
What is this first appeal?
is
ready for
preferred.
hearing?
Yes.
Yes.
Is preferred against the judgment and decree dated 7/12/2015 passed in title suit number 7 of 2012 by the district judge Basigar.
Yes.
Now, my lord, I would not be harping much on the factual aspect of the case, but at later point of time, my lord, for a clarity on the facts, I'll refer to the impugned judgment and decree. Before that, basically, my lord, when I transverse deeper into the impugned decree and judgment and the decree, I find that there is non-compliance of the procedure per se, my lord, laid down in Order 6 and Rule 17/18 of the CPC.
Order 6 rule?
17 and 18, my lord. And more particularly, my lord, Order 14, Rule 2 and 5.
Order 14 rule?
2 and 5.
Yes.
The reason I am referring to for a sort, my lord, is that there was no amendment of the plain while this appellant was made as a party. Because in the earlier proceeding, he was just a pro forma defendant. That is one aspect. And the requirement under
Earlier proceedings meaning?
there will, I will come to that checkers.
But this present
Yes.
first appeal is against the order dated 7/12/15 passed in a title suit.
Correct.
Correct?
In the that's why, my lord, I
And
am
in the
coming.
title suit, they are parties.
Yeah, they are parties. Now they are parties.
R1 and R2.
Correct.
Yes.
So then, my lord, what
And you are for
I am for the appellant R2.
R2.
Yes, Kaliram.
Kaliram
Correct.
You are for
Correct. Yeah, well, very pertinent procedural error
what is the procedural error according to you?
is that already issues were framed. 29 issues were framed, and the learned court below have only taken on board 11 issues out of 29, which is not permissible under law.
Out of 29
9 issues
dealt with only 11 issues.
dealt with only 11 issues. And if my lord will see that there are catena of judgments, that plain cannot be dissected partly. And then, my lord, order 7 dissected partly, my lord. So then this is amounting to that. That is order 7, my lord, rule 11, that my lord knows. Now, my lord, for clarity on the facts, my lord, may I just beseech, my lord, kindly come to my appeal for the facts. That will start somewhere from the page 92, my lord.
92.
92 onwards.
Then after this, my lord, I'll come back to the impugned judgment, my lord.
Yes, 92
And
is an
it-
agreement.
No, my lord, 92 is the appeal.
92.
Yes.
No, in my copy, 92 is,
Hey.
oh, okay.
Sorry, my lord.
Yes. Okay.
Yeah. My lord, the first, we need not to read this, page 93. This is how, the fact starts from page 94, my lord.
Yes.
There's only 3 to 4 or 5 paragraph is important, then I'll come back to the impugned judgment.
Yes. Page.
Page 94, my lord. We read together, my lord.
Yes.
Yeah. That late Tasing Tang brought a suit against Opak Rome, bearing title suit number 3 of 1993 in the Court of Deputy Commissioner, Pasigat, for ownership and delivery of possession of land as well as for delivery of another plot of land if the delivery of plot at Tikra Mirmir is not possible in respect of the land measuring 1 pura located at Tikra Mirmir containing inter area that the plaintiff purchased the said plot of land measuring 1 pura from the defendant Opak Rome on 28/9/1984 at rupees 6,000, and on 23/6/1986 the plaintiff purchased another plot of land measuring 30 feet from the
This is
defendant.
One minute. Will call. Yes.
Yeah. So, from the defendant, and that said plot of land had gone in favor of Sri Kaliram Rigon. Here it is the appellant. The appellant herein, on this strength of Kabal decision dated 19/12/1992, the plaintiff Tasing Taing died, and his eldest son, Dr. Talom Taing, was substituted in the suit, being the eldest male member of the family as per customary law of the community. Dr. Talom Taing, as plaintiff, filed another plaint on same subject matter before the Deputy Commissioner Pasigat without amending. My lord, kindly mark this. Without amending the plaint by impleading Sri Kaliram Rigon as pro forma defendant in the suit. During the pendency of the suit, Dr. Talom Taing died, and the present respondent number 1, namely Srimati Anima Taing, substituted as plaintiff. In the subsequent proceedings, the plaintiff made a prayer for declaration of title, ownership, and interest confirmation of possession over the land in question. 2, my lord, that in the said suit, defendant number 1,
The facts are not there in the impugned order.
it is,
Then let's go to the order.
no, my lord, still I feel that
All right.
well, subject to my lord permission.
Then take your time.
Yes.
No problem.
No, because my lord, I find it, I have compared both the things,
No worries.
but I find that,
You carry on with your flow.
yeah, my younger colleague who has drafted this, I think is bit in a
He's
refined,
covered all the.
is covered all the
All right.
important. That in the suite and the said suite defendant number 1, Omakrome, filed a written statement supported the case of plaintiff, and the said defendant further stated in the written statement that his father gifted a plot of land for pro forma defendant number 2, Kaliram Regon, being his son-in-law. But in the said written statement, the area of the gifted land is not specifically mentioned. My lord will just recall, try to recall this section 75. Suppose if a particular plot of land has become a disputed, in that case, the trial court would have resorted to section 675 of the CPC, appointing the court commissioners. So these particular aspects has not been done in this case, my lord. There was a presumption made by the learned court below while dealing this. My lord, that I skip paragraph 3. that he was transferred here and there. He did not stay for 13 long years.
The dispute is in relation to this particular plot of land.
Yes,
Which according to you, you have purchased.
purchase.
And according to the R1, he had got it by way of a gift.
Yes, it is the,
I purchased.
You have purchased.
no, my lord, both of us.
Oh, correct, because you are R2.
Yes,
So
Both.
according to you, you both have
Yes.
got it by way of gift.
correct. The mischief is by R1, my brother-in-law, who has sold the land.
So
Well,
R1 has sold it to
Yes.
be the bona fide purchaser.
Bona fide purchase. Well, kindly come to paragraph 4. We skip 3, my lord.
Yes,
This paragraph 4 is important, my lord. We'll understand that first
yes.
there was a so and so, then it went up to Supreme
Alright.
Court. That
Paragraph
against the
4 you're reading.
paragraph 4, my lord, that against the said decision of the Kawang, the plaintiff filed suit before Deputy Commissioner Pasigat for challenging the order of Kawang and praying for declaration of ownership and confirmation of possession.
Kebang decided in your favor.
Yeah, 91, 92. The Deputy Commissioner upheld the finding of the Kawang and the plaintiff being aggrieved by the decision of the instituted of the title suit number 3, 1993 on 7/5/1993, which was kept on pending from the year 1993 to 2005 in the court of Deputy Commissioner Pasigat, from where it was transferred to FTC Basar, and on transfer the title suit number 3 of 1993 was renumbered as Basar title suit number 41/06. The judgment of Basar title suit number 41/2006 was pronounced on 34/2007, which went in favor of the plaintiff. Being aggrieved by the judgment dated 34/2007, the aforesaid, the appellant pro forma defendant preferred an appeal before the Honorable High Court Itanagar bench bearing MFA number 02 AP/2007. These Honorable High Court by judgment dated 01/08/2008 upheld the finding of the Deputy Commissioner Pasigat in favor of the appellant pro forma defendant. The plaintiff, being aggrieved by the decision of the Honorable High Court, preferred an appeal bearing civil appeal number 10/222 of 2010 arising out of SLP civil number 27346 of 2008. And the Honorable Supreme Court, by the order dated 02/12/2010, set aside a judgment of the Kawang decision dated 25/3/1992 and 19/12/1991. Deputy Commissioner.
When is this order 1210? By this, the matter was remanded back to the trial court.
Yes, ma'am. That I have this apex court or judgment.
Show me that order
Yeah.
once.
Yes.
Is it part of the paper book?
No, ma'am.
It's available in the record. Certified copies are available in the record.
No, I have downloaded it.
By that, the matter was remanded
Yes,
back.
yes.
My lord, that may not be in that file. It was in some other file. I've seen it. The original.
Anyway, this
Certified
is the
copy.
order.
Yes.
This is the order.
So it was decided to remand it back for consideration afresh.
Correct. ma'am.
Yes, then
So then what has happened thereafter, my lord, in 2012, my lord will aware that the Registrar General versus Union of India judgment that 2013 volume 4 page 11/0
2013 volume
4, my lord.
volume 4.
Volume 4 11/09, my lord. That if my memory is correct, the Guwahati High Court
2013 volume 4 G
GLT.
GLT
Yes,
and page number
11/09
11
11.
111.
No, 11/0
Nine.
09.
Yes.
So there, my lord, in the paragraph 32 and 33, then that dealt with how this judiciary should be separated from the executive. my lord. That,
Anyway, you ask your judiciary to reconfirm the citation
Yes.
and give it to the court.
yes, because in
Yes.
the subsequent division bench judgment, I was part of that case, my lord, so I
Alright.
remember. Navum Nikum case, I will provide both the judgment. So now what had happened, then this case was remanded back then from to the additional district judge passing it. So that is how this came into being.
Came back.
Yes. So, my lord, kindly come to the impugn order. I will not take much of the time.
It's all right. Yeah, no problem.
Yes.
I have the entire day.
Yes.
Except that at 2 o'clock, there is a part third hearing
Yeah.
for the Guwahati bench, which I shall join through BC.
Correct.
You can take the first half and then maybe we can have it on another
First
day.
thought is left with another 25 minutes. Well, I'll finish it. My brother Pangin will
problem.
take. My lord, I kindly come to this kindly the impugn judgment is 25, my lord.
Page
25
of the paper book.
paper book.
Yes.
My lord, this
So,
paragraph,
by this judgment,
correct.
it has been upheld in favor of the appellant, the purchaser.
Purchaser. My lord will kindly come. My lord, this paragraph, up to paragraph 4, we did not to read. This is a reiteration of what we have read in my
Yes.
appeal. Now, my lord, kindly come to page 27. Lord. That is paragraph 5. This is most important.
Why? You have read, I think.
No, my lord, yes, my lord.
Yes.
Now, the case record reveals that on the complaints lodged by the defendant number 2, Kaliram Regon, 2 kavans were conducted on dated. So, my lord, so we read it, my lord. Sorry. 6,
Yes.
kindly come straight to the 6.
This also we have already seen.
No, my lord, here, this paragraph, my lord, now I am referring to Order 6, Rule 17, my lord. Because the record does not disclose that there was an application for amendment of the petition. And
Yes.
no, my lord is aware of that what is pleading is described in Order 6.
Yes.
But only the important order, rule would be 17, my lord, Rule 17.
Yes.
It says, my lord, amendment of pleadings, the court may at any stage of the proceedings allow either party to alter or amend his pleading in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real portions in controversy between the parties, provided that no application for amendments shall be allowed after trial has commenced. Here, my lord, the trial was already commenced. So, meaning thereby these violations.
There has been an
Yes.
amendment.
Yes.
The
I have
amendment is after the matter was remanded back.
yes.
So it
But
was
no-
remanded back.
No, prior to remanding. So therefore, my lord, that even now what happens?
But even, you see, the proviso says no application for amendment shall be allowed after the trial has commenced. Unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before commencement of trial. So there is no absolute bar. If a case is made out,
Then, my lord, this
amendment
has
shall
to
be allowed.
this has to be conjointly read with Rule 18.
so,
Rule
this
18.
proviso is
Yes.
clear.
Rule 18, my lord.
Yes.
So that is.
If a party who has obtained an order for leave to amend does not amend accordingly within the time limited for that purpose by the order, or if no time is thereby limited, then within 14 days from the date of the order, he shall not be permitted to amend after the expiration of such limited time.
Therefore, my lord,
Hmm.
I'm advancing my argument is that
Hmm.
they have not obtained the leave from the court. Thereby, the amendment of the plaint is divorce Order 6, Rule 7.
Sorry, Mr. Tara, I'm not being able to appreciate your argument on
Grateful,
this.
my lord. Grateful.
Can you kindly repeat it? What is exactly that you're trying to draw home?
Yeah.
There has been an amendment
No amendment.
There has been no
No
amendment.
amendment. That's why I'm saying.
So without any amendment, they had amended something without
Yes.
a formal order of
Then they
amendment.
have
Huh?
made me as a
What has
defendant.
been changed?
They have made me the defendant.
Huh?
Earlier, I was only a pro forma respondent in all the proceedings.
Where is the plaint? Page 25. Plaint.
Plaint,
Where is the title suit 7 plaint?
it is, it must be in the record, my lord. It is not here. It is not in the paper book.
Okay.
Got it.
Mr. Pange, can you point out the plaint, please?
Oh, my lord, 1 to 10, the first plaint. One. The first plaint filed before the deputy commissioner is at page 1 to
This
10.
court is concerned now with the title suit 7. Am I correct?
Right, my lord. Yes.
Correct. Now you are saying that in that you have been arrayed as a pro forma and later they have changed you as a proper one. So let me have a look at the arraignment of respondents.
Yes.
The first plaint was filed before the deputy commissioner, and then you will also will find at page 1 of the paper.
Page?
One.
Page 1.
Admittedly, you were the proper respondent.
And then, so now, it culminated from this plaint, it ultimately reached to Supreme Court.
Yes.
And there it was remanded back, correct?
Correct.
Now,
Setting aside each and every order passed by the deputy.
That's right.
Everything.
so,
It's a de novo trial.
therefore, now, there is no question of a fresh plaint.
Yes.
This is the plaint, isn't it? On this basis, now because of separation of judiciary and all, ultimately it was renumbered and re-registered.
Exactly.
Correct? Now, then how come this pro forma defendant became a defendant? Because in the impugned order, which is at Mr. Penging,
Right.
kindly see 25.
Yes, yes.
In 25, they are both shown as defendants. How?
I don't. We started in 1990s, early 90s, my lord. The deputy commissioner was there.
Where
The
is
deputy
the-
commissioner by an order allowed the amendment of the plan.
Where is that order?
That order, my lord, that must be in the record. I will check it out.
Please check up, because then there must be an order.
Yes, there.
Therefore, my lord, I tried to cross check with my younger colleague who has engaged me this matter from Pasigar. And I asked them kindly give me if this is this, otherwise I am going to raise this issue, my lord.
No, you see, you have to be clear because since they are shown as defendant, there must be something on record. So
Something
kindly
on
verify.
Yes.
We look into it and assist the court. When can we have this matter then?
Tomorrow, my lord, or day after tomorrow?
My lord, these 2 days, my lord, I have some personal
When
difficulties.
do you want?
After a week time, my lord, after a week time.
My lord, I am objecting to this. Because this better than pending is 19.
All right, we are posting it on Thursday. By then, you please verify. Okay, just verify that part because an argument is being sought unnecessarily. Suppose that is there, then let judicial time not be wasted unnecessarily.
I will reply to that, my lord.
That is a different aspect, but first let us be
See,
correct on
Milord,
records. If
Milord-
there is an order of amendment, this argument is not necessary.
It goes, it is in
goes.
your favor.
Absolutely. Therefore, first ascertain that whether there is an order or not. Because prima facie it appears R2 is shown as defendant.
Yes.
Whereas in the original plaint he was pro forma.
Pro
How can he be, arraignment be changed? So what has happened? All right.
My lord, this Thursday,
Just take a note.
I
List
told you.
on so and so date for further hearing.
okay. My lord, Tuesday, no?
Next week,
Another
Monday.
Monday can make, Monday, Monday.
Next week, Monday.
Yes.
I would not have, but the 1991, my lord.
No,
My lord, I understand, because we together, with consent, we.
No
The
problem.
person who initially
Yeah.
initiated.
The idea is to finish all matters.
Yes.
So, but we, since this point has been raised, so you ascertain
Yes.
and further hearing on Monday.
Monday, interim order to continue.
Interim order, if any, shall continue till then.
Grateful.
My lord, may I audible?
One second, Mr. Mohanto.
My lord.
Yes, Mr. Mohanto.
Yes. My lord, your probably mic is a little distant from your lordship, probably. মোৰ ভইচটো ডাঙৰ গতিকে দি
Is this okay?
Yes, all right. My lord, I have already submitted my written argument, and in written argument, my lord, I have given details, my lord. In what are the citation we have, my lord, relied upon. That is everything, my lord, in page, everything, my lord, mark, my lord, and each and every query, my lord, which is, my lord, my learned friend, my lord, senior friend, Mr. Saraf has urged, my lord, that will be, my lord, I have replied. So I will not take much time, my lord.
The written arguments, which is signed by Advocate B. Sharma, is for the petitioner or for respondent?
I think we have given, no?
So that is for the petitioner.
Yes, my lord, that is for the petitioner, my lord, and D. Das, Dhurpot Das, signed by Dhurpot Das, that is, my lord, on behalf of the respondents, my lord, 1, 4, and 5.
Yes, D. Das is for respondent.
Yes, my lord. D. Das for respondent for Competition Commission of India, my
And
lord.
who has submitted these volume 1 and 2 of case laws?
No, that is by us.
That is by the probably petitioners, my lord, not by us, my lord. Because whatever judgment we have, my lord, cited, that is included in our in our written argument, my lord.
Yeah, petition. And this also petition. Okay. Yes, Mr. Mahanta.
Yes, my lord. Now, my lord, 6343, my lord. So
Yes,
here in this
6343.
case, my lord, your lordship kindly see that, my lord, Competition Commission Act 2002, that is came into force in 2002. Earlier, there is a act called, my lord, MRTP Act. So monopoly
Competition
trade
Act-
practice, my lord,
Mr. Mohanto, please kindly go little slow.
my lord,
Competition Act came into force when?
2002.
2002.
Earlier, there is a, my lord, act in this type of, my lord, for
Yes, what
monopoly
is it
trade, my
called?
lord.
What is it called?
That is called, my lord, that is Monopoly and Restricted Trade Practice Act 1969.
Monopoly
And Restrictive Trade Practice Act, that is MRTP Act. It is called
and
MRTP Act.
Restrictive Act.
My restrictive, my lord, your lordship kindly has your lordship got, my lord, that is Competition Act 2002.
Yes, yes.
Your lordship straightway goes to page section 66, my lord. Section 66.
Yes, Mr. Mohanto.
Section 66. Repeal and saving this Monopolies and Restrictive Trade Practice Act 1969 is hereby repealed, and the Monopoly and Restrictive Trade Practice Commission established under subsection 1 in respect to 5 of the said act, thereafter referred act, shall stand dissolved. By this act, section 66, my lord, that earlier MRTP Act has been dissolved. So
All right.
now, my lord, this Competition Act 2002, why it is came into exist, my lord? Because, my lord, the trade, the monopoly trade, my lord, cannot be permitted in India, my lord. Although it is not in all over world also, my lord. So just to regulate those, my lord, essential commodities as well as, my lord, commodities which is exclusively made by the some of the companies, my lord. So this Competition Act has come into force, my lord. So here what happened, my lord? This Competition Commission, they are getting complaint. Here what happened in Assam, my lord? We are getting that there are 2 complaint laws against, my lord, the petitioners by the 2 parties. One is state of Assam, other is, my lord, by the
Edida, that is, my lord, respondent number 2.
Second complainant is by respondent number 2.
Respondent number 2, my lord.
Who is
So-
respondent number 2?
Respondent number 2 is Edida, that is, my lord, real estate builders. Assam Real Estate and Infrastructure Development Association.
All
There is
right,
a association of
association.
the real estate builders, my lord. They lodge
Association.
and complain. What are the complaint, my lord? In Assam, your lordship, kindly see the cement price. Because these are the companies, they are dealing with cement. The petitioners companies, they are dealing with the cement, my lord. And my lord, cement price in Assam is much higher than the nearby state, Odisha, Bengal, and Bihar. But these are the company, my lord. They established their, my lord, unit in Assam, getting, my lord, subsidy from state of Assam, as well as state of central government, my lord. But they are pricing that cement in, my lord, Assam is much higher than in, my lord, other state, my lord. So that's why, my lord, and in fact, my lord, there are 3 companies. There are not only this petitioner, other 2 companies are cement manufacturing company also here, my lord. They abruptly, simultaneously, they increase the price. And in the complaint, I am not going to again to the complaint, my lord, only my learned senior fan, I read that complaint and very clearly mention what is the price in Bengal, what is the price in Assam, what is the price in, my lord, Bihar. And because of this, my lord, this cartelization and anti-competition activities, this complaint has been lost. So now, my lord, what is the duty of the, my lord, Competition Commission? Competition Commission, after getting the commission, my lord, after getting the complaint, I will explain the procedure, my lord. After getting the complaint, then commission direct the DG to make an inquiry. At that stage, we are here now, my lord. Simply, my lord, after getting the complaint, then, my lord, commission, my lord, yes, this is a genuine complaint. Then, my lord, direct the DG to make an inquiry. In that stage, my lord, my lord, petitioner came before this honorable court, and there is a stay order passed by this honorable court.
So that inquiry is yet to be done.
Yes, my lord, that stage, my lord. I'll explain everything, my lord. I'll not take much time, but I'll explain this procedure, my lord.
It's all right, Mr. Mohanto. This court has all the time for you. You carry on with your flow.
My lord, my lord. What happened, my lord? Suppose there's suppose just like a FIR. FIR is lodged in the police station. Then, my lord, the concerned officer will, my lord, endorse it that so and so will make an inquiry. So case has been registered, and, my lord, direct the IO to make an investigation. And that stage is somebody, this is just like a quashing of a FIR. So FIR, my lord, when FIR can be quashed? My lord, that is in Bhojanlal's case, my lord, everything has been explained. So, my lord, it is not a, my lord, malafide instituted. It is not a, my lord, abuse of power. Because Competition Act has ample power to investigate this, my lord. So, after getting the complaint, the commission will direct the DG to make an inquiry. Then DG will make an inquiry and he will send a notice to the accused, my lord. They will appear and produce their record. That is the procedure, my lord. So they will produce the record. Then DG will, my lord, submit a report.
Yes.
So that report maybe, my lord, goes in favor of the petitioners or maybe goes in favor of the complainant, my lord. So that stage yet to come, my lord. So now, my lord, DG, my lord, why does petitioner preserve the DG, my lord? After getting all the documents, all the, my lord, considering all the documents, he will submit the report. That is his duty, my lord. Maybe that report, my lord, goes in favor of him or in favor of the complainant.
All right, all right.
So that, my lord, that is the administrative order, my lord. And that order, my lord, it is without any,
that,
my lord, that is...
Mr. Mohanto, which was that provision where this was given, that inquiry has to be done?
My lord, that is 26, my lord. Your lordship, stateway goes to 26, my lord.
Section 26?
Yes, my lord.
just indicate which is the stage that you are in now from the provision.
We are in 26-1 notice, my lord. Now he is challenging the
26-1.
26-1 notice. One, has your lordship got
Yes,
section
26.
26, my lord?
Yes.
Procedure for inquiry under section 19.
Now, before that, just section 19 once.
19-1, my lord, complaint laws, my lord. 91 procedure will come later on, my lord.
1 second, 1 second. Let me just recapitulate. I think on the last occasion, Dr. Saraf had placed reliance on section 19.
My lord. 19-3, my lord.
19, just read 19 once and then we'll go to 26.
My lord. The commission may inquire into any allegation, contravention of the provision of contained in subsection 1, subsection 3, subsection 1, section 4, either on its own motion or on receipt of any information in such manner and accompanied by such phase 3 as may be determined by the regulation from the person, consumer or their association, trade and association. Referral made in by the central government or state government or any statutory authority. Without prejudice to the provision of the contained subsection 1, that the power and function of the commission shall be include power and function specified in subsection 3 and 7. The commission shall, while determining the where agreement has been appreciable adverse effect on competition under section 3, have due regard to all the any of the following factors, namely the creation of barriers, new entrance in the market, driving essential competition of the market. So these are, my lord, section 3 will come after what? Not now. Now, your lordship, kindly see, my lord, section 26, my lord.
Yes.
That is in case of determination. Determination part will be later, my lord. Your lordship, kindly see, commission shall, while determining, that will not, that stage yet to come, my lord. So that's why, my lord, that 19, my lord, other procedure will not come right now, my lord.
So you see, Mr. Mohanto, under section 26, only after existence of a prima facie case, the Director General shall be directed to cause an investigation, correct?
My lord.
In the present
No, my lord,
case, that has been done.
My lord. No, not yet done. Not yet done. That has been stayed here.
Correct. If I have correctly understood right now, there has been an order to the Director General to make an inquiry.
Inquiry, that's it.
Correct.
Investigation, my lord.
But you see, Mr. Mohanto, if you read subsection 1 of 26, it indicates prima facie that the prerequisite to cause that investigation is the satisfaction of a prima facie case. Am I correct? Kindly read subsection 1 of 26.
My lord, on receipt of a reference from central government or a state government and statutory authority or its own knowledge or information received under section 19, if the commission is of the opinion that there exists a prima facie case, it shall direct the Director General to ensure an investigation to made an into the matter.
Correct.
So, yes, commission has, my lord, thus, my lord, satisfied that there is a prima facie case, and then he direct the Director to make an inquiry.
Correct. And if I recollect, Dr. Saraf had argued that here that prima facie satisfaction has not been generated.
That is not, that is an administrative order, my lord. That is not required to record, my lord.
No, but I am just trying to appreciate the contentions of both parties. Dr. Saraf, that I believe that was what your argument was, right?
I know that is, in fact, my argument was that, that before directing the Director General,
a prima facie satisfaction has to be generated.
And prima facie satisfaction must be on the basis of the section 3 requirements and 93.
Very well. All right. Okay. Yes, Mr. Mohanto, you can carry on.
So, my lord, in that stage, my lord, your lordship kindly see that 26-1. So that is, my lord, that the commission direct the DG to make an inquiry.
Yes.
So DG will make an inquiry and submit the report.
Yes.
And that report, my lord, in that stage, my lord, he has a right to go on merit. The accused has a right to, my lord, argue on merit. Accused has cross-examined all details he has to place before them, my lord. Then, my lord, if the order passed against him, then there is a provision for appeal under section 53. So after, my lord, 53, my lord, an appeal, my lord, there is a provision to, my lord, make an, my lord, go to the Supreme Court, my lord. So in this stage, my lord, why I am submitting before your lordship, I will place, my lord, in my written argument, my lord, all the judgment, which is, my lord, regarding 26(1) notice, my lord. So what is the findings given by the court, my lord, that is already, my lord, I place in my written argument, my lord. Your lordship kindly see that my learned friends argued that yes, prima facie satisfaction has to be on the record, my lord, that has been. My lord, that is absolutely administrative order, my lord, from one departmental one wing to another open just to keep the my lord complaint on motion. At this stage, we cannot enter in the merit of the case, my lord. That is the content, that is the judgment passed by my lord, several judgments passed by this honorable court, my lord, honorable apex court, my lord. And in fact, my lord, nowhere in India, my lord, any high court passed the notice under section 26(1), my lord. And that is a very preliminary stage, my lord. No prejudice caused to any of the, my lord, petitioner, any of the parties, my lord. Neither the complainant nor the, my lord, the accused, my lord. It is just to make an inquiry. Otherwise, my lord, the main purpose of this act will be frustrated, my lord. Your lordship kindly see, it is a prima facie, my lord, in complaint itself, my lord. It is very clearly, my lord, they have stated by the court that who are the complainant. One is state of Assam, other is, my lord, one registered organization. They have clearly explained everything. So we just want to make an inquiry. In that stage, my lord, if the court stop it, that you don't go for going in inquiry, then, my lord, it is, I think, my lord, the entire purpose of this act will be frustrated, my lord. So your lordship kindly say, my lord, at this stage, my lord, we cannot enter in the merit of the case. We cannot even discuss the merit, my lord. Because in the complaint itself, there is cert given, my lord. What are the price in, my lord, other state? What are the price in? So that's why, my lord, the Director General asked them to produce, my lord, some document. In that stage, they cooperate, but they did not submit some of the document, my lord. That's why, my lord, they are taking time one after another. That's why, my lord, fine was imposed. That against that fine, my lord, another petition file, which is, my lord, already here heard by your lordship. Against that order, my lord, there is a appealable order. So that I already argued in the last occasion. I have argued, my lord. Now, my lord, your lordship kindly see that regarding prima facie satisfaction, my lord, for that, my lord, that our, my lord, my learned senior friend knows it very well. There is a very well judgment, my lord, pronounced by our High Court in, my lord, that is by Honorable Justice Manish Chaudhary. And that I have already annexed, my lord. In that judgment also, my lord, confirmed by the division bench, my lord. In that case, my lord, also clearly deal with this, all this, my lord, queries made by the my lord.
Which page of your compilation?
That is, my lord, your lordship will find page, my lord, it is 25.
All right.
But they page 25, then, my lord, appeal, my lord, preferred by the petitioner, my lord, that is, my lord, your lordship will get. That is page 53, my lord. In
Page
my
53.
53, my lord. In my written argument, everything is page mark and with the index, my lord. So now, my lord, regarding that, prima facie satisfaction at, my lord, is where it is recorded, my lord. Your lordship will, my lord, there is another judgment from our High Court. That is from Mizoram. That is Mizoram, my lord. That is 2022 7 SCC, page 73. I have annexed in my written argument, that is page 77.
Page 77 of your compilation.
Compilation, my lord.
Yes.
So your lordship kindly see the page 89, para 33 of my compilation, my lord.
Page?
In that case, my lord, there is a stay order passed by the Mizoram High Court, Guwahati High Court of Mizoram bench, my lord, and matter was pending, my lord. In that case, what happened? I'll just give the background of the case, my lord.
Page,
my lord, it is start from page 77.
No, which
now
page
I want
you want
to
me
refer,
to
my lord,
go?
page 89.
89?
89. Para 33.
Yes.
In that case, what happened, my lord, in lottery, Mizoram lottery, and Mizoram lottery case, my lord, all the tenderer, my lord, with cartelization, my lord, they all the tender are giving us absolutely same rate in the tender process. In that, my lord, tender process, Mizoram lottery is permissible in Mizoram. And then there is a complaint filed against the Commission of India, and that complaint was stayed by this state in the, my lord, Mizoram High Court, my lord, and Mizoram government went to the Supreme Court.
Yes.
Mizoram government went to whether government is also liable to the under Competition Act or not, my lord. While deciding that case, my lord, there is a finding, my lord. I'll read them para 33, my lord.
Yes, please.
Page 18 and para 33. That is a submission,
Yes, I have
my lord.
it.
Then later I'll come to
I
the,
have
my
it.
lord.
You may read.
Lastly, it was argued that the High Court ought not to have entertained a petition under Article 226-27 of the Constitution of India, an order passed under Section 26(1) of the Competition Act was in nature of an administrative direction. There was no adverse civil consequence. The proceedings were akin to a show-cause notice, and even the DG report did not amount to a final decision. The respondents were also stated to have the alternative efficacious remedy on appeal under Section 53B of the Competition Act, where it is could approach the appellant. A tribunal aggrieved at by any decision or direction under the order entirely and subsection 2 of the Section 26 of the Competition Act. The Commission is expected to form an opinion about the existence of the prima facie case of the contravention of the certain provision of the Competition Act, and then pass a direction for a DG to cause an investigation into the matter. Post the report of the DG can proceed further in close of the proceeding. CCI also so and so. That I'll come to that. CCI case I'll again come to that. That stage had not even arisen. The final report of CCI has yet to be matured, and CCI was not even bound by the report of the DGP. In fact, my lord, again I am submitting, my lord, DG, my lord, when the Director General making an inquiry submit a report, the Commission is not bound to accept the report, my lord.
Is it
They
in
may
a
not accept.
recommendation form?
My lord?
Is it recommendatory kind of
Yes,
report?
my lord. Yes, my lord.
Or it will be required to be further acted upon?
Yes, by 26/6, my lord. 26/6.
26/6.
My lord. Your lordship kindly see 26/6, my lord.
Yes. If after consideration.
If after consideration, objection, suggestion, refer to the subsection 5, if any of the Commission agreed with the recommendation of the Director General, it shall close the matter forthwith and pass as other order as it deemed fit, and communication is order to the central government or state government or to the statutory authority for parties concerned as the case may be. So, my lord, when DG file a report, that is, my lord, open to the Commission. They will again, my lord, they will scrutinize, and if they are satisfied that there is no, my lord, there is no violation of any condition of the Act, my lord, then they dispose of it, my lord. Then they drop it. Then
it is recommendatory. Basically, this inquiry.
Yes, exactly, my lord. That is the word. Exactly. There's an investigation, my lord. He will find the investigation just like filing a search sheet, my lord. That search sheet may be, my lord, accepted by the court or not. That is a, my lord. And that stage, my lord, he will get all opportunity
Mr.
to hear,
Mahanta,
my
you
lord.
are submitting that no prejudice is going to be caused to the
Exactly, my lord. That is my
petitioner. And if at such stages also this court has to interfere, then the object of the act is getting
That will be my lord,
frustrated.
my lord.
Correct?
My lord,
Because
that is my
all
submission,
proceedings will get delayed.
Delayed, my lord.
This is what you want to argue,
Exactly,
right?
my lord. Now, my lord, your lordship kindly see finding of this case, my lord.
Yes.
Page 92, my lord.
Yes, please.
Page 92, my lord. Para 47 of the judgment. That judgment which was I just now I read, my lord.
Page 92.
Page 92.
Yes.
Para 47. We would like to say that the intervention by, has your lordship got it, my lord?
Yes, please.
We would like to say that the intervention by the High Court was extremely premature. It ought to have waited for CCI to come to the conclusion, but on the other hand, that had happened in the CCI proceeding have been brought to a standstill with the High Court opinion that the basis of some aspect which may or may not be arise. We are thus view that there is really no need for High Court to proceed with the matter and the direction sought to be proceeded. the correct approach more so once the statement was made on behalf of the CCI would have been closed the proceeding filed by the state government and let the private parties face the ultimate decision of the CCI. If they were aggrieved by the adverse decision of the CCI, they were entitled to avail the appellate authority under Section 53B of the Competition Act. So, my lord, clearly mentioned that, my lord, is a premature, and this stage, my lord, in fact, we cannot enter in the merit of the case, my lord. If I entered in the merit of the case, nothing left to, my lord. DG to investigate,
All right.
my lord.
All right.
So now, my lord, your lordship kindly see that prima facie satisfaction. Here, another, my lord, judgment I have annexed, my lord, that is page 94, my lord. The Competition Commission of India was a Steel Authority of India. That is delayed by my learned friend also, but that is helped me.
Yes.
Your lordship kindly see para 28. 22, para 28.
Yes.
Page 108.
Yes, I have got it.
As already noticed and exercise of power, the competition is expected to form an opinion on the existence of the prima facie case of the contravention of certain provision of the Act. Pass the direction to the Director General to cause an investigation into the matter. Those proceedings are initiated by the intimation reference received from the Commission of any of the manners specified under Section 19 of the Act. Therefore, very threshold, the Commission is to exercise power passed in direction of the investigation, or where find that the execution has no prima facie case is justified in passing such a direction to the Director General, it can close the matter and pass such order in it may be ordered deemed fit proper. In other words, in order passed by the Commission under Section 26(2) is a final order and is put to end of the proceeding initiated upon receiving information one of the specific mode. This order has been specifically made appealable under Section 53 of the Act. The contravention of the direction under Section 26(1). After formation of a prima facie opinion is directed the simpliciter. Direction is a simpliciter to cause an investigation into the matter. Issuance of such direction at the face of it is an administrative direction to one of its own wing departmentally and without entering upon any adjudicatory process. It does not effectively determine any right or obligation of the parties to the list. The closure of the case causes intermediation to the right and effect with the party. The intimation cause resulting the said party has the right to appeal against the closure of the cause under Section 26(2) of the Act. On the other hand, mere direction for investigation to one of the wing of the Commission to akin to a departmental proceeding which does not entail in civil consequence for any person, particularly in light of the strict confidentiality has expected to be maintained by the Commission in terms of the Section 57 and regarding 30
This squarely draws home the point that you have argued, Mr. Mahanta.
My lord. My lord.
This squarely draws home the point that you have argued.
My lord. My lord.
Yes.
Now, then, my lord, your lordship kindly see, my lord, then everything will be, then your lordship kindly page 69, page 121, para 69.
Page
121. Page 121, para 69.
Yes.
The jurisdiction of this commission to act under provision does not contemplate any executory function. The commission is not expected to give notice to the parties. The informant of the appropriate parties, they hear that at length before forming the opinion. The function, it is a very preliminary nature, and it had the common parlance. It is a departmental function. At that stage, it does not condemn any person, and therefore application of the alternate pattern is not called for. Formation of a prima facie opinion departmentally, Director General being the appointed by the central government to assist the commission is one of the wing of the commission itself. Does not amount to any adjudicatory function, but is merely a administrative nature.
In this case,
no determination, my lord. It is administrative order, my lord. Absolutely.
In this case, the issue was whether a notice is required before the apex court.
That, my lord, even, my lord, that when report is commission get the complaint, then commission send direct the DG to investigate the matter. In that stage, not even notice is required.
That is
to
what
give
is
the
has
accused.
been held in para 69, correct?
My lord. And my lord, why it is I'm submitting, my lord? In that act, my lord, there is a very, very important section, my lord, that in that act, my lord, if the complainant apply for confidentiality, then even some of the document which is produced by the, my lord, informant, my lord, cannot disclose to the complainant on because it's close to the accused on that point of time, my lord. So in that case, my lord, complainant can apply for confidentiality, my lord. So that's why, my lord, that stage is the administrative order, my lord. Whether, my lord, after getting the complaint, so simply direct the DG to make an inquiry.
It is like a fact-finding commission.
My lord, exactly, my lord. So that's why, my lord, in 26(2), my lord, commission can drop this, my lord. Commission can close this, my lord, close this complaint. Then, my lord, either of the party goes to appeal. So that is the stage, my lord. Now, my lord, probably that point is your lordship, my lord. All the judgment, my lord. In that, my lord, in that manner, my lord, it is a premature one. It is a, my lord, administrative order. There is no prima facie, my lord. Satisfaction is, my lord, word to word recording is not necessary, my lord. That is there, my lord, in all the judgment which I have placed, my lord. Now, my lord, your lordship kindly see another point, my lord.
Yes.
My learned friend, my lord, says that it has to be, my lord, within 60 days. It has to be within 40 days. There is no, my lord, time limit prescribed by the Act. Time limit prescribed by the, my lord, one of the judgment. That is, my lord, in respect of, my lord, DG report. DG, my lord, after making an inquiry, DG have to submit report that, my lord, not by the Act, my lord. The Act is not, there is no time limit provided by the Act.
Within how much time the DG has to submit its
there is, my
report?
lord, normally there is no mention, my lord. It is, my lord, up to the commission, my lord. But one judgment of the apex court, my lord, which is cited by my learned friend, my lord, that, my lord, in fact, in that same judgment, very same judgment, I will come to that, my lord. I'll meet that query, my lord. Page 132 of the my compilation, my lord.
Page
132. That is the very judgment which I have read, my lord. Page 132, section 96, subsection subclause D. Page 132.
Yes.
The Director General, in terms of the Regulation 20, is expected to submit this report within a reasonable time. No inquiry by the Commission can be proceed any further in absence of the report of the Director General in terms of the section 26(2) of the Act. The report by the Director General should be submitted within the time of the time as directed by the Commission, but all case not later than 45 days from the date of passing the direction terms of section of the 26(1) of the Act. So that stage, my lord, he has yet to file report, my lord. But already it has been stated. But another very important point, my lord, there is a complaint against 2 other companies also. In the complaint, my lord, because simultaneously while cartelizing, my lord, they have abruptly raised the price of the cement, my lord, in Assam. That's why we issue notice them also. But because of this stay order operating, my lord, we cannot proceed who are not before this court also. So my submission before, he has already, my lord, in compliance with the notice of the DG, my lord, he submit some report, submit some document, my lord. So he has, my lord, entered in the proceeding, my lord. He complied with the DG's notice, my lord. So at that stage, let the DG file a report, my lord. Why he pleases, my lord, the DG, the Director General, my lord. He may pass order in his favor, or Commission can drop them, my lord, after going through the entire documents, my lord. So whatever the argument he has made before this honorable court, he can make before the Commission, my lord, before the DG, my lord.
And he can also file an appeal.
My lord, then that is why I am submitting, my lord, it's a very premature stage, my lord. And if he is not, any order passed against him, Here is a my lord, he is a provision in the act, my lord, is a special act, there is a provision, my lord, statutory appeal, he can go ahead, go with the appeal. And in the appeal failed, then he can directly go to the Supreme Court, my lord.
Now, Mr. Mohanto, this prima facie satisfaction, because the statute contemplates that some prima facie case has to be made, correct?
My lord.
Now, what according to you would that mean? Because one cannot ignore that word also. So some
that is, I am
some satisfaction.
that is
perhaps
reflected in the
required.
order, my lord. Because your lordship kindly see very well in the complaint itself, it is a very well manner, it is my lord projected. So that my lord, your lordship
No,
kindly
but
see
there
the,
is no agreement between the three companies, and this was
that
not
will my
done
lord come into the
together.
inquiry, my lord, because simultaneously they have raised the my lord price of the price in
You
Assam.
see, one argument which is an interesting argument which was made is this three companies coincidentally
No, my
hike
lord,
the
that has
price
to be
on the same date, but
My lord.
different amounts.
My lord.
Now, obviously, in that situation, three companies would not be benefited. You see,
No,
one
that is the
company
cartelization, my lord.
is
There
going
is
to
a- I am
be at a
submitting, my
loss
lord.
now. They are not part of the same management. So,
My lord.
so in that case, why should the other company get into such an agreement?
That has to be finded out, my lord. When there is a complaint, that has to be finded out, my lord. That's why, my lord, we are giving notice to them also, my lord. So your lordship kindly see that is cartelization, my lord. Suppose, my lord, there are three companies. They says that yes, in Assam, whatever you price in other state, they will, my lord, they will raise the price of the cement, my lord. So that's why, my lord, there is need to make into the inquiry, my lord. That's why, my lord, that commission, but DG asked them to produce all the documents before him. So after getting all documents, all whether if there is, your lordship rightly pointed out, yes, maybe a coincidence, but whether it is a coincidence has to be, my lord, inquired by the DG, my lord. So
Because
that, my lord,
prima facie as suspicion has been raised, correct?
My lord.
This is what you are
Yeah,
saying.
yeah, exactly, my lord. Exactly, that's what. In the complaint itself, my lord, by the government of Assam, my lord, it's very clearly mentioned it, my lord. So that's why I'm submitting, my lord. That is the administrative order. That order is, my lord, nowhere in any high court is being interfered, my lord.
So according to
premature
you,
stage,
the
my lord.
fact that it was done on the same date itself is sufficient for
My
the
lord, my lord.
direction to the DG
That's
to
why,
cause
my lord,
the
in
inquiry.
DG
That
the
is
commission has that simultaneously they have raised, my lord.
that itself is sufficient according
Sufficient,
to
my
you,
lord.
Mr.
So that is
Mohanto.
my
Nothing
submission, my
more.
lord.
Because
My lord.
the commission will inquire, and if there is something, then
My lord, they will proceed,
then
or if nothing, they will drop it.
Correct.
So that is the stage, my lord. So
All
now,
right.
my lord, probably that is the main query, my lord. So because at this stage it is not proper for us to entering in the merit, my lord. If I
Right.
discussed, my lord, then it will be, my lord, that will be amounting to, my lord, we are entering in the, my lord, merit of the case and make a submission, make a submission on merit, my lord, merit of the, my lord, that there nothing left for, my lord, DG to inquiry, my lord.
Right.
So my submission before your lordship, it's a very, very preliminary stage, my lord. No any fundamental right of the petitioner has been violated. Because just ask them to make an inquiry, it will not, my lord, cartelization of any of the fundamental right of the petitioners, my lord.
All right. At this point, we have this court has noted. Yes.
My
Anything
lord.
else?
So, my lord, now, my lord, already from there, my lord, regarding that's why in the premature stage, that's why I'm submitting that it is not maintainable at this stage, my lord. In their compilation, your lordship kindly see that he argued on maintainability point. He has given a judgment. In judgment, one para was also quoted. But that para, but subsequent para is not been quoted. I'll read it, my lord, which help me.
Maintainability, because you are saying it's premature. That is
Premature,
your
my lord.
attack on maintainability, isn't it?
My lord, because
Right.
your lordship kindly, my lord, take up his, my lord. I have to answer. That's why, my lord. His part one. There's a two volume, my lord. First volume, my lord.
Volume 1.
First volume, my lord.
Yes.
In 6343.
Page?
Part A, page 55.
Page 55.
Page 55. Maintainability, page 55, my lord. Has your lordship got part one, my lord? There are
Yes,
two compilation, my lord.
Yes, I've got it. This is the Rajasthan cylinders case.
No, but before the maintainability of the writ petition against the order passed under section 26(1) of the Competition Act 2002.
No,
There is well
Mr.
settled-
Mohanto, I'm not, you are relying page 55 of volume 1.
Volume A. Volume
Volume
A,
A.
but that is of the my lord, the written argument of the my lord, my writ petitioner, my lord.
Volume A.
Written argument, your lordship kindly see the written argument of the my lord, writ petitioner, my lord.
Page 55.
Page 55.
Got it, got it. Yes.
It is well settled law, a series of decision of the apex court, if any order is without jurisdiction or exercise of jurisdiction, then the writ petition under Article 226 of the Constitution assailing the said order shall be maintainable. A similar issue came up for consideration of the apex court Competition Commission of India versus Bharati Airtel. So that Bharati Airtel judgment, my lord, that is an in different context, and that is also the, my lord, in our division bench judgment it is discussed, my lord. I will place, my lord, that is already placed before your lordship, my lord. Your lordship, that's Honorable Justice Sandeep Mehta and Justice Medari Thakuria's judgment, my lord. In that case, my lord, why it is maintainable says,
Yes.
yes, my lord, and that case, the Bharati Airtel case, my lord, that is, in that case, my lord, there is a conflict between two acts. One is Competition Commission of India's Act, my Competition Act, and other is, my lord, TRA, Telecom Regulatory Act. So, who will proceed? And that case, my lord, there is a case between there is a conflict between Telecom Regulatory Act and Competition Act, my lord. In that situation, my lord, we went to the court, my lord, and that says there is a jurisdiction. That is in a different context, my lord. And in fact, in that judgment, the observations which were made is absolutely in my favor, my lord. Your lordship kindly, the judgment, my lord, the Competition Commission of India versus Bharati Airtel, judgment.
Volume 2, case 769.
Volume 2?
Volume 2. No, I am not going to volume. You have given a very volume, my lord, that which is very bulky.
Dr. Saraf, page?
769, my lord.
So, my lord, volume 2, my lord, probably he has that is annexed.
Yes.
Page 770, relevant portion, my lord. Para 122.
Yes.
In that judgment, my lord, has your lordship got in volume 2, my lord, page 773?
Yes, yes. Page 1, paragraph 121.
121, where the
Yes.
High Court could give its finding on merit. 121. Once we hold that order under section 26(1) of the Competition Act is administrative in nature, and further that it was a merely a prima facie opinion of directing the DGD General to carry out the investigation, the High Court would not be competent to adjudge the validity of such order on merit. That is in a very clear term, and that judgment, my lord, it is reflected, which is
This
relied
is
by
the
my lord Fenman, but it is helped me.
This is the Bharati's case.
Yes, my lord. That is
I
the
will be 120, my lord.
Competition Commission of
120.
India versus
Yes,
Bharati Airtel.
There are 120, my lord, merit.
121, my lord.
120 also merit.
Thus,
So,
even when we
Director
do not
General of carry
agree
out the
with
investigation on
approach,
High Court will not be competent to adjust the validity of such order on merit.
Mr. Mohanto,
Orders on
just
the High
read
Court
121.
therefore may not be appropriate,
Read 121.
my lord.
120, my lord.
So I have read 121, my lord.
Read 121.
Yes, my
Para
lord.
120.
120. Thus, even we do not agree with the approach of the High Court labeling the impugned order as quasi-judicial order and assuming the jurisdiction to ascertain the writ petition on that basis, for its own and different reason, we find that the High Court was competent to deal with decide the issue arising as exercise of its power under Section 26 Constitution. Writ petitions were therefore maintainable. That is in conflict of two judgment, two act, my lord. That is,
Okay.
my lord, in context of the, my lord, writ petition, my lord, and what is the subject matter of the petition. That writ petition, my lord, was filed. There is a conflict between, my lord, Telecom Regulatory Act or, my lord, Competition Commission of Act. Then to decide on that. But regarding 26(1), 121 observation is very clear, my lord. So we are taking the part of 121, my lord.
All right.
What is stated in 121, my lord. So that is my submission, my lord, regarding, my lord, this query, my lord. So other judgment, my lord, which was, my lord, given by even in its compilation, my lord, all are on merit. All are afterward, after the DG report, my lord, not before that, my lord. But I have gone through, my lord, all the judgment, my lord. My learned junior also, my lord, doing very good homework, my lord. But regarding 26(1) notice, my lord, there is no interference by any high court, my lord, till now, my lord. So my submission before your lordship, at this stage, my lord, it is premature stage, that if your lordship, my lord, this honorable court interfere with the, my lord, to DGP to make an inquiry, then, my lord, the whole purpose of this act will be frustrated, my lord. So my submission before your lordship, I will sum up, my lord. Your lordship kindly see in the last portion of my compilation, my lord, written argument, my lord, page 24, my lord.
Yes, page 24.
Page 24. Another point, my lord, since that is raised before this honorable court, point of review. There is no power of review in this act, my lord. That has been repealed, my lord. Section 37, my lord. Section 37, my lord.
Yes.
Section 37, my lord, that is repealed in 2007, my lord.
All right.
So that review power is not there. Now, my lord, page 24, my lord, conclusion, my lord. I sum up that, my lord. The present writ petition is premature, and as such, the honorable court does not have any jurisdiction to adjudicate upon the validity of the order passed under section 26 of the act. That is my I have already explained, my lord. The order of investigation, the ground raised by the petitioner, all are in merit, which the honorable court is not empowered to adjudicate upon that in terms of the power conferred upon the Article 2 of the Constitution of India. The order of the investigation passed by CCI under section 26(1) is act of only to trigger an investigation. Thus, my lord, the DG to put in motion, my lord. In that stage, my lord, then abuse the power and law by invoking that jurisdiction of the honorable court not be permitted. The CCI has acted within the mandate of the law and has correctly rejected the order review recall upon by the so. So, my lord, now your lordship kindly again I am submitting, my lord. When, my lord, the commission ordered the DG to make an inquiry, no any right of the anybody's parties has been, my lord, determined. So that's why if no right of the determination has been determined, my lord, nobody's right has been infringement, my lord. So since there is no violation of the any fundamental right, then, my lord, writ petition is, my lord, at this stage is not maintainable, my lord. So other judgment, my lord, which I have annexed, my lord, clearly I am indicating, my lord, what is other power is relevant to us, my lord. And everything, my lord, page mark. Your lordship kindly see that my written argument. And so far is judgment cited by my learned friend. These are all, my lord, merit in, my lord, after, my lord, this is the report, after passing order by the commission, my lord. So not in this stage, my lord. So observation regarding, my lord,
all right.
I have already, my lord, made my submission.
All right.
That is my submission, my lord.
Dr. Saraf, anything to add?
No, my lord.
Yes, my lord. Yes, my lord.
Yes.
Certainly. My lord, before I give reply.
So probably, my lord, my learned friend is, my lord, representing one of the complainant, my lord.
One respondent number 2, my lord.
Yes, you want to add something?
Yes. My complaint is at page 43, annexure 1.
Page
43, annexure 1.
Yes.
This is from Assam Real Estate Infrastructure.
Yes, I
Developers
think this was
Association,
already read extensively by the petitioner, so you may keep the reading, but what do you want to submit?
No, my lord, my argument is well covered by my learned brother.
Yes.
So I will not take much time of the court.
Very well. You are adopting the arguments of Mr. Mohanta.
Yes, yes.
All right. And you are for respondent number?
I'm for respondent number 2.
R2. And Mr. Nath, you are?
No, I am appearing for the respondent number 3, brother.
R3.
For the respondent number 3. But,
Anything you want to
I
specify?
adopt the, I adopt the
You are the
submission
first
by-
complainant.
I am the first complainant. My complaint is at page 61.
Page?
Page 61.
Yes.
And my lord, here, Lordship already, I'm just reiterating, my lord, I adopt the submission of Mr. Mohanta, my lord, for the respondent number 1. And my lord, I'm just reiterating that after the complaint, the impugned order, there are 2 impugned orders in this petition. The first impugned order, Lordship will find at page, my lord, 66. There, my lord, prima facie para 7.
Page 66.
Page 66, it starts. Then, my lord, kindly, I'm just pointing out the relevant pages, my lord.
Yes, page 66 of
The writ petition, my lord. But this is 6343 of 2018.
$66.
Page 66, my lord. In the writ
I am
petition.
holding 6342.
My lord, kindly take up 6343, my lord. 6342, possibly hearing is already concluded, my lord.
6343.
43.
6342. Any order was passed?
Well, on the other day, Lordship has heard that matter. My lord, we are not in
That is the penalty matter.
6342 is the penalty matter, right?
My
Yes,
lord.
yes. 6343 we are appearing. There, my lord, my complaint, Lordship will find at page. Complaint, Lordship, kindly note, my lord, page 61, my lord.
Page 60.
Page 61. It's a detailed complaint, my lord. I'll not read, my lord. I'll just.
Yes,
I'll
yes, I have got it.
Lordship, I'm just indicating, my lord. Then, my lord, kindly see there are 2 impugned orders in this case. My lord, the first impugned order, Lordship will find at page 66.
Yes.
Page 66. Here, my lord, para 7, I will refer at page 71. After receipt of the complaint was, my lord, it was acted upon, and para 7 at page 71.
Yes.
Based on the above observations, the commission is of the view that there exists a prima facie case. And considering that prima facie case, my lord, the
Yes, and there was meeting of minds.
Meeting of mind and page
So
73.
that prima facie satisfaction has been generated according to you.
Yes, 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 my lord. Page 73, kindly see. The
And it
last
is
paragraph.
evident from this para 7.
Yes, my lord.
Yes.
Para 7 and page 73, the secretary is directed to send a copy, and the officer in charge of the so-and-so DG to act accordingly.
All right.
Then, my lord, the second impugned order, kindly see, my lord.
Yes.
There are two impugned orders.
Yes, yes. Second one page.
Second one, my lord, kindly see.
Page.
Page 99. Page 99, my lord.
Yes.
But here from paragraph 2-3 paragraph, I'll just refer.
You just give me the para numbers, Mr. Nath.
Para 5, my lord.
Para 5, then?
Para 5 is the first, they refer to the first order, 6/12/2016, that because of considering the prima facie case, the process was started. Kindly see, my lord, para 8.
Para 5, para 8, any other para?
8, my lord. I'm just reading, my lord. Kindly allow me to read the para 8.
Yes,
my lord.
yes,
Yes,
please.
So it has been averred that the information have been filed with mala fide and ulterior motive and with design of securing unfair and undue advantage over OP1. OP1 has further submitted that certain tax invoice cash memos submitted by purported to show price of OP1 are forged and fabricated. The invoice issued by so-and-so private limited is forged as the IP1 had added the tax so-and-so. And basically, I want to just refer that on this application has been filed for recalling review of the first impugned order. The second order has been challenged that this review order has been dismissed. Kindly see the last portion. This ultimately it's a detailed order, my lord. At last portion, it has been, they have found page 107, my lord.
Yes. Yes.
After
rejected.
considering all the things, my lord, it is that as noted above para 27, as noted above by the Honorable High Court, the jurisdiction of review recall should be exercised only if without entering into any factual controversy, the Commission finds no merit in the complaint reference on which investigation has been ordered. In the present case, as noted earlier, Commission prima facie found merit in the information received from IP1, which is an association of real estate developer, and reference received from IP2, which is a state government, and as such investigation was ordered. In the result, impugned application of OP is misconceived and the same is directed to be rejected. This is the second impugned order.
Yes.
But 26, my learned senior friend has already referred. 26 prescribed a detailed procedure, after receipt of complaint under 19, 26 is the detailed procedure, and this in a similar situation, in the written argument, it has already been placed before your lordship, the decision of this Honorable High Court. I'm just all the decisions have already been referred, I'm just indicating the judgment passed in WPC number 76 of 2022. It is a part of the written argument, given submitted before your lordship, by the
This is
respondent
Justice
number 1.
Chaudhary's judgment.
Yes.
All right.
That is in their written argument at page 25. I'm
Page?
just in page 25 in the written argument of respondent number 1, page 25.
Okay.
There I will just refer to 3-4 paragraphs. Kindly take kindly note, para 20, 21.
Yes.
23.4 and 26,
And 20?
20, para 20, para 21.
No, last para you mentioned 20?
23.4 and 26.
26, okay.
Logical.
Yes.
Para 20, 20 and 20, it refers to the.
It's all right.
Logic. I'm not reading, after receipt of the information under section 19(1)(a) received from an informant alleging contravention of section 3 of the Competition Act, the Commission has to satisfy itself and has to express its opinion that a prima facie case exists, and then it will the course of action will follow under 26(1). Then in paragraph 21, regulation 18 of CCI regulation has been referred. Regulation 18 of CCI regulations, para 21. Lordship may kindly take note of that.
Yes, regulation 18.
18, Malad.
All right.
Lordship. Para 21. Then, Malad, paragraph 23.4. Malad, 23.4. The honorable court has taken note of a Supreme Court decision, Malad. 2 paragraphs have been quoted in that paragraph. Para 38, just I am reading 2-3 lines, Malad. In contradiction, the direction under section 26(1) after formation of a prima facie opinion is direction simpliciter to cause an investigation into the matter. Issuance of such a direction at the face of it
Is
is an
what
administrative
simpliciter?
direction to
Mr.
one
Nat,
of its
Mr. Nat, what simpliciter? What is the word used?
paragraph direction simpliciter. Kindly
Direction simpliciter. All right, proceed.
para 23.4.
All right.
In the compilation, the first judgment I am referring to.
Yes.
In contradiction, the direction under section 26(1) after formation of a prima facie opinion is a direction simpliciter to cause an investigation into the matter. Issuance of such a direction at the face of it is an administrative direction to one of its own wings departmentally and is without entering upon any adjudicatory process. It does not effectively determine any right or obligation of the parties to the lease. This is the reference has been taken. The Honorable Supreme Court decision has been quoted under this paragraph. And the last paragraph, para 26. Lordship may kindly take note of that.
Yes.
But the Honorable Court has taken note of the fact of, in that particular case, para 26, reverting back to the fact of the case in hand, the case in that particular writ petition, it is found that the information lost by MS ONGC Limited, as stated earlier, are in respect of 4 tender processes of the year 2013, 15, 17, and 18 for purchase of oil well cement. In the formation of MS ONGC Limited had provided the data and the rates quoted by the opposite parties in those tender process. From the data and the rates quoted by the opposite parties in those 4 tender processes as reflected from the competitive statement depicted in the information, it is easily noticeable that the opposite parties had quoted identical prices in respect of few of the destinations. Such competitive statements have been tabled in paragraph number so and so of the information. Well, this information is the information which was filed before the competition commission. The complaint information is complaint which we have also filed. There prima facie data has been given, that has been taken into consideration. On the basis of that, the 26 investigation was started. So there is similarity of the I am referring to this because in the second impugn order, they have filed an application that the materials which were given in the complaint, those are false, fabricated, and therefore the complaint is void. These are prima facie materials given. They have applied their mind. Prima facie view has been formed, and therefore investigation has been the fact-finding inquiry has been directed. Therefore, in my respectful submission, the writ petition deserves to be dismissed. There is no merit in the case, and at this stage of preliminary inquiry only, if the investigation is stopped, ultimately the main object of the act will be frustrated. Section 3, I'll refer section 3. That is the object, and ultimately, Competition Commission will not be in a position to act any more if it is not allowed. That is my respectful submission.
All right.
I'm obliged.
Yes. Dr. Sharaf?
My lord, first of all, the submissions advanced by my learned friend that no High Court of the country has yet passed the order, and thereby this court should not pass any order. My lord, only some High Court at some point of time, unless until they pass the order, and all the High Courts have not passed, so the another High Court will not pass the order without looking into the merits of the case, then there will be no judgment at all from any High Court, and all will follow the another High Court. So this is not a ground at all to say. Secondly, to say that, my lord, the writ petition, your lordship has no power, or the High Court is not empowered to entertain the writ petition, my lord, that is absolutely incorrect. That the High Court is not empowered, or High Court, your lordship cannot entertain the petition under 226. That is absolutely incorrect. Your lordship may not exercise the discretion. That is a different thing. But nobody can say that your lordships don't have the power. Lordships' powers are, there is no limit up to 26. Your lordship may not, in a particular case, decide to, my lord, exercise the power in 226. But to say that the High Court doesn't have the power according to me, that is absolutely incorrect. Now, my lord, my short submissions before your lordship was that, my lord, that section 3 and has to be read with 19.3, and the commission must come to a prima facie finding. I have never said that the merit of the case is to be examined. No, I've never submitted that the merit of the case is to be examined. My learned friend said about, gave example the FIR. My lord, if the FIR lodging investigation will be made, then FIR will never be quashed. Your lordship, by quashing the FIR day by day, then the FIR will never be quashed. What harm is there? He will investigate. But if the FIR does not disclose the commission of any offense, then FIR are quashed. Now, prima facie case, your lordship may kindly see, my lord, the volume 2 at page 770. This is the part of the Bharti Airtel judgment.
Yes, page
770, my lord.
770.
0.
Yes.
Para 97, my lord.
Yes.
The 5th or 6th line, my lord. Even if, as you lordship got in, my lord,
Yes, it's highlighted.
even if it is a direction under any of the provisions and not a decision, conclusion or order passed on merits by the commission, it is expected that the same would be supported by some reasoning. At the stage of forming a prima facie view, as required under section 26(1) of the Act, the commission may not really record detailed reasons, but must express its mind in no uncertain terms that there is a view or that it is of the view that the prima facie case exists, requiring issuance of direction for investigation to the Director General. Such view should be recorded with reference to the information furnished by the Commission. Such opinions should be formed on the basis of the records, including the information furnished and the references made to the Commission under the various provisions of the Case Act as aforementioned.
Yes.
So it's not so, my lord, that the Commission 26(1), otherwise the very purpose of incorporation of the words forming a prima facie of the view would be frustrated. As my learned friend said, that the object of the act will be frustrated. According to me, the 26(1) would be frustrated. There is some intention behind of the legislature in including the words forming and prima facie opinion. Prima facie means you cannot just say that the information will come and prima facie I am satisfied. No, you have to go through, examine, and find out whether section 3, the conditions, whatever are there, have been violated or not. My learned friend was saying that everybody has increased some prices. In the order of the commission itself, it has been mentioned that who increased how much prices, and also what is the price of the cement of the 3 companies. All the 3 companies raised prices differently, and the prices of the cement of all the 3 companies are different. Even after increase, the prices of the cement of all the 3 companies are different. Now, the purpose of the Competition Act is that, my lord, there should be proper competition. The competition should not go. If I am selling a cement at 210 rupees, somebody is selling at 215 rupees, somebody is selling at 220 rupees, how it can be said that there was a cartel and thereby to thwart the competition, my lord, the entire process was taken. Now, my learned friend was again and again emphasizing that it is administrative order. No doubt about it is administrative order, because the Bombay High Court held that it is quasi-judicial order. The Supreme Court said that no, it is not quasi-judicial order, but it is administrative order. But even then, my lord, for what reason, whether it was jurisdiction question, the 2 Act was complained. If 26(1) no petition will lie, then it will not lie, whatever may happen. If 26(1) the petition will not lie, then it will not lie under any circumstances. You can't say that this was the case, as such the 26(1) petition would lie, but in this case the 26(1) petition will not lie. If that is the case, then your lordship will certainly examine whether in this case the 26(1) the petition will lie or not. Now, my learned friend was saying, well, on the one hand, he made a submission that under 26(1), against 26(1), the administrative order, no writ petition will lie at all. When he was referring to the Bharti Airtel case,
That probably this court will not go into, because the question is whether some case is made out or not.
my
That is
my
the-
submission, my submission is that, my lord, the judgments which I will next is that what is the jurisdiction, that the Supreme Court says that if the, assuming, my lord, section 3, what are the conditions which are there, if they are not violated by means of on the basis of the facts of the case, you can't direct an investigation, because you have to form a prima facie opinion on the basis of the provisions of section 3 of the Act.
Yes,
So
you had
the-
submitted this on the last occasion.
My lord, that is, my lord, I'm again reiterating for the sake of again reiteration, because we are, my lord, in the Arunachal Pradesh, I rarely get a chance to have a virtual, my lord, hearing the lordship sitting in the virtual and easily sitting there, my lord. So my submission before lordship is that, my lord, the sale judgment which my learned friend was citing, that judgment was taken into consideration in the Bharti Airtel case. And after consideration of that, my lord, the sale judgment was delivered. Now, my learned friend was referring to the Mizoram case, lottery case. My lord, a single line, if my learned friend can point out that the jurisdictional issue was raised before the court. If there was no issue of the jurisdiction raised in the said case, normally lordship will never interfere in 26(1) case. I am referring to it. When a order is challenged to be without jurisdiction or in excess of jurisdiction, your lordship will interfere. But my learned friend was referring to lottery case. Lottery case, your lordship, and I've given the written submission also, referring to the Mizoram case. That Mizoram case, no argument was advanced that 26(1) order is without jurisdiction or in excess of the jurisdiction. The court was not called upon to decide whether 26(1) order is without jurisdiction or excess of jurisdiction. Much emphasis has been given on the judgments of this honorable court by Justice Manish Chaudhary as well as the division bench. Your lordship will find that was a matter where the interim matter was being considered. The court has directed them to file affidavit and the matter is pending. The court has not dismissed the writ petition on the ground that the writ petition is not maintainable. The court refused the interim order but directed the respondent to file affidavit. Matter is again listed for hearing. In fact, the matters are coming for hearing. And the division bench also, my lord, that matter went against the interim order. There was no order dismissing the writ application. Otherwise, on the very first day itself, the court could have dismissed the writ application, not considering the interim application. That 226, the 26(1) order, the writ will not lie at all. The court has not dismissed the writ application. Instead of that, court was considering only the interim order. And you'll also be aware, while considering the interim order, the observations which are made by the court at the interim stage, well, that will not influence the final hearing of this petition. So these two judgments which my learned friend was referring, in my humble submission, has no bearing, because that was not a case at all on the merit, and the court has not dismissed the writ application. The writ application are pending. In fact, we have taken the adjournment day for yesterday on the ground that the similar matter is being argued before your lordship. So, my lord, these two judgments now are not referred. Bharti Airtel, I have referred to before lordship. Sale judgment has been referred in the Bharti Airtel judgment, and after referring to that judgment, my lord, the order has been passed. Now, your lordship, again and again, the submissions have been advanced about, my lord, that what is the effect? Nothing is there. What is the direction in the administration? My lord, I may just, although I referred to it before lordship, but by my own satisfaction, I may refer to, my lord, the judgment of the Delhi High Court in Google, my lord. What does it mean? Volume 1, page 396.
Page number?
396, my lord. a relevant part, I will take your lordship to page 443. 442, my lord.
Yes, 395,
And 11 page at page 441, my lord. 441.
Yes,
And my lord,
yes.
the Supreme Court in so-and-so, cited by the Council for the Respondent number 2, complainant also held that an investigation against a public company tends to shake its credit and adversely affects its competitive position in the business world, even though in the end it may competitively exonerated and given a character certificate that the very appointment of the inspector in the case of 237B of the Companies Act to investigate the affairs is likely to receive much press publicity as a result of the reputation prospects of the company may be especially affected. When the effect of an order of investigation under Section 26(1) of the Act can be so drastic, in our view, availability of an opportunity during the course of the proceeding before the CCI, after receipt of the report of the DG to defend itself, cannot always be a ground to deny the remedy under Article 226 of the Constitution of India against the order of the investigation. Though we do not intend to delve deep into it, but we are reminded of the principle in cases of violation of fundamental right, the argument of the same causing no prejudice is not available. Your lordship may skip over, my lord, page 444, my lord.
Yes.
Again, as the CCI can order direct investigation only if it forms prima facie opinion of violation of the provisions of the Act having been committed, our constitutional values and judicial principle by no stretch of imagination would permit an investigation where, say, CCI orders direct investigation without forming an expressly a prima facie opinion, or where the prima facie opinion, though purportedly is formed and expressed, is palpably unsustainable. The remedy, yes, is High Court. The remedy of Article 226 would definitely be available in such cases. Even otherwise, the remedy under Article 226 of the Constitution of India has been held to be a part of the basic structure of the Constitution, and your lordship may skip over. Thereafter, next page below. P, my lord.
Yes, Madras.
A division bench of Madras High Court held that the bar in Section 61 of the Competition Act to the jurisdiction of the civil courts in respect of a matter the CCI or complaint is empowered to determine does not apply to the jurisdiction of the High Court under 226 of the Constitution, which has been held to be a part of the basic structure. Your lordship may skip over page 446. 5, my lord. A single bench judge of the so-and-so High Court held that a writ petition Article 226 to be maintainable against an order direction for investigation by the DG under the Monopoly and Restricted Trade Practices Act, so-and-so, which Competition Act repealed while Section 66, of course, in the cases of inherent lack of jurisdiction or abuse of the process of law or jurisdictional cases. Now, your lordship may kindly see, my lord, at page 455.
Yes.
It is also ZL below. It is also not as if the investigating powers of the DG are unlimited. The DG CCI conducting the investigation is bound. It is also ZL.
Z?
L.
L. Okay. Yes.
My lord. It is also not as if the investigating powers of the DG are unlimited. The DG CCI in conducting the investigation is bound by the confines of investigation set out in the orders of the CCI under 26(1) of the Act, and is not empowered to conduct a roving and fishing inquiry. This is also evident from Section 26(7) of the Act empowering CCI to direct Director General to cause further investigation in the matter, and from Regulation 26 of the Competition Act of India, General Regulation 2009, empowering CCI to direct DG to make further investigation. It is thus not that once an order of Section 26(1) of the investigation has been made, the investigation goes out of the domain of the CCI. This I am referring for the reason, my lord, that the whole ground is that on one day the prices were increased by particular prices. Now the DG has asked for about, I think, more than 1 lakh mail of the company, starting from investigation, making as if, my lord, he is making investigation from the entire business of the petitioner. the inquiry which was to be made was whether the 40 rupees was increased on that day or not. He has asked for the mail. I've given written submission. Mail about lack of the email of the company from the very beginning to the sent to the Director General. Now, Your Lordship may kindly see, my Lord, at page 461. My Lord. We therefore,
461.
my Lord.
Yes.
Para 21, my Lord.
Yes,
We
yes.
therefore answer the question framed hereby for adjudication in affirmative and hold that Despondent number 1 CCI had the power to review the order under section 26(1) of the Act, but within the parameters and subject to the restrictions discussed above. This finding has been given in spite of the fact by noting that the review power has been expressly deleted. But then the court said, although review power has been deleted, but if the CCI finds that the order was passed on the wrong footings, then the power of the review will be there. Now, my Lord, the similar only on the issue is coming on the prima facie case. That whether prima facie case is, what is the meaning of the prima facie case? My Lord, similar language has been used in the Companies Act, and I've given the citation. Wherein, below the apex code was considering the question that whether it is a discretionary means whether it is absolute discretionary or not. And the apex court said that no, it is not a discretionary as you say, but it must be supported by reasons. Some prima facie case does not mean that one has the prima facie view, as my learned friend says, that it was not necessary at all because it is administrative order. My Lord, otherwise all administrative order, judicial review of the administrative order, my Lord, when your lawsuit is examining, there will be no examination at all because it will be a prima facie view. And a person can say that by noting that whatever has been given information, I am on the prima facie view that, my Lord, the opinion has been, there is a prima facie case. As Bharti Airtel said, you must give reference to the provisions of the Act and the materials, and on the basis of that, you must to conclusion that there is a prima facie case. And that's why, my Lord, in all the judgment, my learned friend was saying that they are not relevant at all. My Lord, I have given the judgments on the issues that what is the meaning of the jurisdictional issue and what is the error of jurisdiction. All the courts have said, my Lord, jurisdictional issue is also there where the person is directed to do something. And if without considering the materials or the reasons, he exceeds and without examining that he passes the order, that will be without jurisdiction or in excess of jurisdiction. So, my Lord, the question, it cannot be said by any state of imagination that, my Lord, he has got a blanket power, because my learned friend was again and again insisting what prejudice is being caused. As your Lordship has seen, the Delhi High Court said that causing of the prejudice is not only the reason that the 226 will fall lying the 226. If the order is illegal, then one cannot say that what prejudice has been caused to you. If the order is illegal, then it is illegal. One is not required to, my Lord, the proof that prejudice has been caused, and thereby only I will interpret. Your Lordship may kindly see, my Lord, the decision on the I was referring to, my Lord, the decision of the I'm sorry, my Lord, I'm just taking 1 minute, my Lord. What is it? Well, one judgment. You'll also find Supreme Court didn't refer to issue. My lord,
Yes,
but the one decision of the Calcutta High Court, which I'm finding out because I've given the reference of the Supreme Court also on the
no
same
problem.
issue. My lord, where the similar words were used in the Companies Act, which you'll also find at page 657 of volume 2.
Page
657, my lord.
volume 2 is having pages only to 503.
Well, this is volume 2 of mine, my lord.
Oh, sorry. This is volume 1. Give me volume 2. Page number 600, Dr. Saraf.
657, my lord. 657.
Yes, please.
My lord, you'll also see the page 664.
Yes.
Paragraph 24, my lord.
Yes.
The proposition that opinion should be objectively formed as contended by the Mr. Dev is unacceptable if the opinion formed is of the type referred to in the cases relied on by him. For example, opinion as to necessity of imposition of the collective fine, opinion as to necessity of detention of the opinion as to requirement of land for the purpose of acquisition of land extra. The opinion to be formed under section 2377B of the Companies Act is, however, not of the type of the opinion. That mind of the authority when it makes an order under clause B of section 270 is of the explanatory stage, and that is the reason why it has been proceeded on the circumstances suggesting the existence of the malpractices mentioned in the subclauses 1, 2, and 3. The expression "if in the opinion of the central government there are circumstances suggesting" means that it appears to the central government that there is a likelihood of the language used in section 4 of the Law Acquisition Act, that if the central government is proceed to on circumstances suggesting that it can merely proceed on hypothesis, that is to say on prima facie theory, to be proved or disapproved with reference to the facts later on ascertained. Now, if the character of the investigation is merely that of the fact-finding commission, as pointed out by Supreme Court in so and so and so and so, the central government cannot be expected to form a fully objective opinion about the malpractices clause in so and so before the establishing two relevant points of opinion of such opinion. It may merely form an opinion that there are circumstances which may be capable of innocent interpretation, but until that is so done, suggestively sinister, this is a form of opinion which is lesser in degree the fact of self-confident opinion based on the regional material commodity so and so. You'll also may thereafter skip over and come to my lord. I'm giving the judgment of Supreme Court of Law, that is the more elaborate. In the written submission, my lord, I've given the reference of it, but that is Rohtas Industries, my lord. Rohtas Industries citation. So that is volume 1, page 83.
Volume 1, page 83. Yes, Rohtas.
My lord.
Paragraph?
My lord, I will take your lordship to page 87.
Yes.
Paragraph 3, my lord.
Paragraph 2.
Paragraph 3.
3, yes.
3, my lord.
Yes, yes.
The High Court dismissed the interpretation holding that the opinion formed by the central government under so and so hereafter is not open to judicial review. The impugned order declares that the central government has formed the impugned order and the same is conclusive. That conclusion of the High Court is challenged in this court. When this appeal came up for hearing on so-and-so, this court directed the respondent to file further affidavit, placing on record the complaints mentioned in so-and-so of the aforementioned affidavit of the so-and-so. The said affidavit has been filed. So first of all, your lordship may kindly see that similarly what my learned friend was submitting, that 126(1) order is there. The 226 itself is not maintainable. Where the High Court dismissed it, the apex court directed them to place the materials before the court. Now your lordship may kindly see, my lord. I will take your lordship to page 95.
Yes.
Para 6, 8, my lord, the court was discussing about the discretion, and after the, my lord, in Nakula Ali, you lordship may see the quotation portion, last 5 lines, where the controller has reasonable grounds to believe that any dealer is unfit to be allowed to constitute a dealer as imposing conditions, there must be in fact exist such reasonable grounds known to the controller before he can validly exercise the power of cancellation.
So there has to be some grounds based on which the prima facie satisfaction has to be generated. That is
My
what
lord.
you are trying to say.
My lord, now I'm only on the conclusion part, I will take your lordship, my lord, at page 99. Para
Yes.
12, my lord. Para 12. The last, my lord, the para 12. Next question is whether reasonable authority, much less expert body like central government, could have reasonably made the impugned order on the basis of materials before it. Admittedly, the only relevant material on the basis of the impugned order can be said to have been made is the transaction of sale of preference shares of so-and-so. At the time when the government made the impugned order, it did not know the market quotation of the ordinary share of that company as on the date of the sale of the shares or immediately before that sale. They did not care to find out that information. Hence, there was no material before them showing that the threshold for the inadequate differentiation. Now, posing here, my lord, my learned friend is there saying that, my lord, whether the informations were correct or not, whether those things are there or not, that will be examined by the investigating agency. Now, here your lordship may see the apex court is saying that they have not cared at all to find out whether that things are correct or not. Now, your lordship may further see, my lord. They did not care to find out the information. Hence, share was more material before them, showing that they were sold to inadequate consideration. If, as it now proved, that the market price of those shares on the May so-and-so was only 11 per share, then the transaction in question could not have been afforded any basis of forming an opinion required under section so-and-so. If the market price of the ordinary shares of the company on about so-and-so was only 11, it was quite unreasonable for the directors to conclude that the price of ordinary shares is likely to go down so-and-so. Now, their argument was that it was increased by the same day by such and such prices. Now, he's saying that that will be examined. Now, here the apex court said, if the prices were not so, then there was no case at all. Further, Lord Smith, we do not think that any reasonable person, much less any expert body like the government, on the material before it could have jumped to such a conclusion that there was any fraud involved in the sale of the shares in question. If the government had any suspicion about the transaction, it should have probed into the matter further before directing investigation. We are convinced that the present action taken by the government was not called for and could not be justified on the basis of the materials before it. The opinion formed by the government was wholly irrational opinion. The fact that one of the leading directors of the appealing company was a suspect in the eye of the government became the precedent, assuming without deciding that the allegations against two are true was not a relevant circumstances. That circumstances could not have been allowed to cloud the opinion of the government. The government is charged with the responsibility in forming a bona fide opinion on the basis of the relevant opinion. The opinion formed in this case cannot be said to have been formed in accordance with law. So the court thereafter kindly.
This is under the Companies Act, Dr. Saraf.
Companies Act. Well, Companies Act. The similar provision was there where the government has to form an opinion. Now, page 100, your lordship, can you see, my lord?
Yes,
Para 2.
yes.
Section 237B provides that the central government may appoint one or more competent persons to or inspectors to investigate the affairs of the company and to report thereon such matters as the central may direct, if in the opinion of the central government there are circumstances suggesting. Now here also the investigation is to be directed, my lord, by this government. Now this was interpreted in this case by the apex court, and the apex court said that no, you don't have the power like that to direct anything. Where, my lord, in this case the submissions are there that this is a 26-1, so there is no question of anything inquiring, etc. All will be done by the persons of inspectors. But here in this case, you will also see that the Supreme Court said that the forming of the opinion was irrational, was not on the basis of the materials which were there. High Court dismissed the petition that this is only a case of investigation, but the Supreme Court ultimately reversed the same. So, my lord, this is not a, I have never argued, my lord, before your lordship, that your lordship should go into the merits of the case. But to make a person subject to the investigation simply on the basis that the information by the real estate was given on the basis of violation of section 3 and 4. The commission had not taken into consideration 4. The commission has taken into consideration only 3 and 3. 3 only. Now, if 3, where is the agreement? If the agreement is there, my lord, can it be a different prices? Somebody is increasing 28 rupees, somebody is increasing 15 rupees. Can it be said to be an agreement, a cartel to increase the prices? I can understand that the cement prices are the same and they are increasing the same and there is no other option. When you yourselves are saying the other persons from outside are selling at the lesser rate, then where is the question of affecting the market? The purpose is that the market should not be affected by way of forming a cartel. That you have to purchase the things from this particular person. When your own allegation is that the cement is available from Bhutan or somebody at a lesser rate, their only grievance is that you are not passing over the subsidies to the people, and you are not selling at the lesser rate. Selling at a lesser rate is not at all a condition under section 3(3) of the Act. Subsidies are not to be passed over. The judgments of the Supreme Court in PVR and Guwahati High Court, and as well as the Supreme Court judgment, subsidies are by way of an incentives for establishing the industry in the backward region. That is not to be passed over to customers. Their only grievance is that if these subsidies come to this much, so you should reduce the price by 150 rupees. That is not a competition. That is not anti-competition. Anti-competition is altogether different. To say that why you have not reduced the price, how it can be anti-competition? It cannot be anti-competition. And only because an appeal lies after passing of the final order, that in my humble submission cannot stop a person from challenging an illegal order which has been passed without jurisdiction and without fulfillment of the conditions which have been laid down in section 3 of the Act. Section 3 of the Act has got a particular purpose. My learned friend says that the entire purpose of the Act will be frustrated. I say that if 26(1) order is passed mechanically, the entire purpose of the Act will be frustrated and it will become such an Act which will have a drastic effect on the industries. You have been given a power to do something on the particular things, conditions. You don't look into it and you say that you sit down, we'll investigate and thereafter we will come to it. What is the harm? What harm? The same thing can be in the FIR. That yes, we are investigating, it will be closed. How you are prejudiced? Why the complaints, the criminal complaints are quashed? There cannot be in such a submission, that what prejudice is caused, why they should not, why I should give the lakhs and lakhs of the communications and go to there. And my reputation is there. Somebody else is at the Delhi High Court said that even if I am discharged, the damage which has been done to the company will never be repaired. So my humble submission before your lordship is that, my lord, that the lordship will see that whether my lord 26(1), the grounds which he has given, and the commission itself in its order, in the review order is writing that this company has increased by this prices, this company has increased by this prices, and this company has increased by this prices. In fact, the other two companies, which are in West Bengal, they also increased the prices on the same day. I mentioned it in my written submission. They have also increased, maybe by 10 rupees, maybe by 20 rupees, maybe 15 rupees. So it's not so. And in the market, my lord, when one person comes to know that somebody has increased by 30 rupees, he may increase by 20 rupees. Somebody may increase by 10 rupees. But that is not a cartel. Cartel will mean when there is a meeting of mind by way of an agreement, forcing the people to purchase a particular product at a particular price. Otherwise, he has no option at all. When the option is available at reduced price, which person is going to purchase for the higher prices, my lord? If the market, my lord, one type is available at 200 rupees, assuming I am charging very high prices, another person is selling at 150 rupees. Can I remain in the market? I will be out. But you cannot force me that you must sell at the same price which he is selling. That will be anti-competitive. If you force me that you must also sell the cement at the same prices which another person is selling, that is not the object of the Competition Act. Where will be the competition then? People will have no option. They will have to purchase at the same price itself. So what they are doing is anti-competitive instead of making it competitive. Different prices indicates that there is a competition. Now you are forcing that they must have similar prices. How it can be? And who is, before Lordship Makanisi, the real estate, who are the consumers of the cement, and they themselves are saying that landed cost of the Bhutan cement is 225 rupees. Either you must say that Bhutan cement is of the inferior quality, so I must purchase the cement of these three companies only. If my three companies cement is better, then price will be higher. So either you have to say that you have never said that we cannot purchase the Bhutan cement because of its inferior quality. So if it is of the same quality, why you are purchasing here from the Star Cement? Don't purchase. Go for the Bhutan cement. You want to purchase the Star Cement also because of the quality, and you say that you sell at the same prices which others are selling, which may be of the inferior quality. If somebody is selling the mobile phone at my residence at 100 rupees, and another person is selling the same thing at 150 rupees, will I go for purchasing at 150 rupees? I will go for purchasing 150 rupees only when I find that the another one is of the inferior quality. So, my lord, my submission before Lordship is that, my lord, in this case, the commission has simply acted mechanically, because Lordship find that what the informants have submitted, he has noted, and then says, I have come to a prima facie opinion. Now, 19.3.
No inquiry made.
No inquiry made, which my learned friend is still be saying the inquiry will be made later on. Why inquiry now? The prices were increased or not increased. They are saying that the same prices, and the commission is still be saying that not the same prices. Different prices were there. I will just refer to it, that the commission is saying that the different prices were increased, that this company increased by these prices, this company increased by these prices. So the allegation which was there, that the same prices were increased on the same day, that is absolutely incorrect. And on that basis, if somebody is initiating the proceedings, my lord, in my humble submission, that is absolutely illegal, contrary to the provisions of the Act. Allegation was something else, and you have not made an inquiry, and after you make an inquiry, you say that no, these are different, on different dates, different prices were increased, but my lord, we'll examine later on. My lord, that according to me, my lord, is absolutely outside the powers of the commission. And this is a most irrational exercise of powers, which in the language of the Supreme Court, that no reasonable person, normal person, not to speak of the expert body like the commission, can pass such an order that we will examine it later on, but the conditions may be fulfilled or not fulfilled. We are passing the order. My lord, such a power had not been conferred, and no court will allow any authority, whether it is administrative authority or whether a quasi-judicial authority. After all, you're also daily dealing with the matters of the administrative authorities, and administrative authorities, it passes an order with one line, you'll also will struck down that, set aside that one. And the more drastic effect is that, my lord, that we are not heard because there is no provision for hearing. There is no provision for hearing the other inferences. So you must be more careful because you cannot hear the person who is affected. You are passing the order only on the basis of the persons, my lord, somebody else. You will also kindly see, my lord, page 64 of the petition.
Yes.
You'll also see page 64, 1, my lord. Paragraph 1.
64.
My lord.
Page 64 is annexure 3.
My lord, that is a petition. I think you'll also be taking 64.3.
64.3.
64.3. I'm sorry, my lord, I'm just kidding. 64.3 and 4.2 is making.
In fact, I need a clarification about both the cases. This court is also confused.
The
One
6 to
case,
4
I think we had already finished the other day.
My lord,
Anyway,
the 6 to,
you finish this, then I'll get to the other case.
6242 is the penalty, my lord, and 6343 is the main matter.
The written arguments that you both sides have submitted relates to 6343, correct?
Exactly.
My lord, I've given both written arguments in both the
But he is
cases.
giving for both.
Dr. Saraf, you have also given argument on 6342.
My lord, I've separately, my lord, I've given.
And because in 6342, if I recollect, the only argument made by Mr. Monto was alternative remedy. Alternative remedy. You say it is without
And that order
jurisdiction.
passed by the authorities is a revision order, and there is an alternative remedy. Well, he can file an appeal, man.
Yes,
No,
yes.
I'm admitting that there is appeal. I've never said that there is no appeal. I've never said, my lord, that there is no appeal. How I can say?
Yes, because your case is that no jurisdiction, without jurisdiction.
Without jurisdiction, and I've said, my lord, that the pure question of law is there, that whether penalty could have been imposed when the reasonable cause word is there. So, and on that, my lord, you'll also see page 71, my lord. 6343.
Page
71.
Yes.
You'll also see. 71, 1, my lord. OPs, my lord.
Yes, I've got it.
OPs simultaneously raise prices of their respective brands of cement in tandem on so-and-so from the price data submitted as collected from the tax invoices of OPs different states in the month of August. It is observed that on 17/8/2000, OP1 has raised the price per bag of cement from 240.45 to 366. So this is, my lord, comes to rupees, my lord, 16 rupees. You'll also see.
Yes.
OP2 has raised the sale price of baked cement from 325 to 365.
This we have, this court has already marked on, you had shown us.
So my submission for that, my lord, the argument which are the complaint which were there, on the same day they have increased by 40 rupees. That is not correct. The commission itself is and seeing, and the prices you'll also see, one is 375, another is 366, another, my lord, you'll also see, third one is. So when the prices are different of different brands of cement, my lord,
there is no curtailment according to you.
there is no curtailment, cartel, and there was no increase of the prices. One has increased by 16 or 17 rupees, another has increased by 40 rupees.
This is something where even this court had pointed a question, because The only thing is that there is coincidentally, it was done on the same date. Now, because of that, some
Well, if the-
suspicion
I'm
is
just-
caused.
I'm
I agree fully with you, Dr. Saraf, that there doesn't appear to be any agreement on the face of it. And these are three different companies. There is
Well, I
no
would just
doubt.
submit a reply to it, my lord. That suspicion cannot take the place of the forming a prima facie view. Only suspicion is not the reasons. When you have got your materials, you pass the order, you have noted the prices,
Yes.
then it cannot be said that there will be cartel. A company, another company will never agree that I increase by 40 rupees, you increase by 25 rupees, you
Yes,
16
this
rupees.
argument you've also placed on the last.
Certainly,
I
my lord.
remember. I remember.
So, my lord, my submission for lordship is that, my lord, that this petition, in my humble submission, is maintainable in view of the judgment of the apex court.
Yes.
Secondly, my lord, your lordship will never examine the merits of the case. Your lordship will examine that whether the preconditions for section 3(1)
Yes,
exist or not.
All right.
And that is my humble submission for your lordship, my lord. I'm really grateful to your lordship for, and two judgments of the Guwahati High Court that were only on the interim matter. There is no, in fact, the court has directed the other side to file affidavits and the matter is in the hearing. So the court has not dismissed the petition that 26(1) order the petition will not lie at all and dismissed at the threshold. No.
All right.
That has not been done. So, my lord, this is my humble submission for lordship, my lord.
All right.
Well, only one line. I want one word, my lord. Just I want to add, my lord.
Reply to reply, Mr. Mahanta.
No, my lord, definition of agreement. Definition of agreement, my lord, your lordship kindly see. In the act, my lord, agreement, your lordship kindly look into that, my lord.
I've given the written submission.
Definition of
Agreement is
agreement, my lord.
defined.
My lord,
Agreement is
definition of
defined.
that's why I good, my lord, new point, my lord, that's why I'm submitting.
Yes,
Agreement
agreement.
include any, my lord, for doing a criminal activities, my lord, there is no registered agreement, my lord. Here, that is why it is very defined in the, my lord, act. Agreement include any agreement, understanding or action in concert. Very important, action in concert. That means simultaneously you have done action. So agreement.
Where are you reading from, Mr. Mahanta? Where is the definition of agreement?
That is, my lord, section 2, my lord.
Section?
Section 2 of the act.
Yes.
Definition clause, my lord.
Yes.
Agreement include any agreement or understanding or action in concert. It's very important is that, my lord. So
Okay,
you lordship kindly look into that, my lord.
All right.
That is my submission.
In fact, my lord, in the written
I
submission,
conclude, my lord. I'm very grateful to your lordship, my lord, being patient hearing, my lord.
in the written submission at page
I'm
7.
sorry, my lord, your lordship, my lord, sitting in my
It is
honest room, we are
always
disturbing, my lord.
enlightening to hear legal luminaries like you both.
No, I am not sure, my lord. This is I'm learner, my lord. I'm totally, my
Yes.
lord. In this competition, there are very few cases here, my lord.
My lord, the word cartel has also been defined. I've given in the written submission at page 7 and 8.
All right.
7 and 8 with agreement also given.
What I will do is I will post this matter.
My lord, we are not in a
7th of
hurry.
May.
Your lordship, take your own time, my lord.
I'm saying hearing partly concluded. Post list this matter again on 7/5/2024.
My lord,
If there is, in the meantime, if anything is there on that day,
My
I
lord,
shall take clarification and close it on that day.
My lord, 7 is a
Otherwise,
holiday
it
in
is
Assam, my lord.
Elections.
Or
Because of
you-
in
right.
Guwahati, my lord, not only
Election.
Assam, Guwahati.
Election.
Election, my lord.
Then,
I don't think, my lord, your lordship will need any further clarification because.
Yes, my lord.
On 9th?
My lord, no problem.
Yes.
Deeply
On
object.
9th.
Well, lord, even if, my lord, 9th and 10th, I will not be there because the marriage of my junior is there. But, my lord, if anything is there, then my lordship may keep it on 9th. If anything is there, my lord.
All right. Otherwise, I'm reserving it.
My lord.
In case there is something, I'll get it
Then, my
relisted.
lord, yes.
My lord,
Hearing concluded, reserved for judgment.
Deeply object.
I'm highly
All
obliged,
right.
my lord, for taking your lordship's time to sitting
No,
in
no,
dialogue
no,
for this. In fact, that is the advantage that sitting in 2 hours, we could have done it. Otherwise, going to Arunachal Pradesh.
No, but in fact, it was very comfortably done through VC.
Yes, my lord, we are very grateful, my lord.
And I could utilize my time here.
Yes, my lord.
Yes, my lord.
Grateful to your lordship.
All right.
Deep day.
लिखी दीवा